ನೋಡ್ತೀನಿ, ನೋಡ್ಕೊ. ರೀಲಾಗಿನ್ ಅಷ್ಟೇ, ರೀಲಾಗಿನ್
ಏನಕ್ಕೆ?
ಅದಕ್ಕೆ ನಿಮ್ಗೆ ಅಲ್ಲಿನ ಪಿಕ್ಚರ್ ಬೇಕಂತ ಈ ಮ್ಯಾಟ್ರ್ ಮುಗಿದ ತಕ್ಷಣ ಮೆನ್ಷನಿಗೂ ಅಲ್ಲಿ ಪಿಕ್ಚರ್ ವಿಡಿಯೋ ಆಧಾರ್ ಬಡ್ಸ್ಗೆ ರೀಲಾಗಿನ್ ಆಗು.
ಯಾಕೆ ಸ್ವಿಚ್ ಓವರ್ ಆದ್ರೆ ಆಗ್ಬೇಕಲ್ವಾ?
ಆಗಿಲ್ಲ, ಯಾರು ಗೊತ್ತು. We don't know that how it works. Off that case.
My lordships, kindly.
All memos to the court officer. Yes.
Your lordships, kindly.
All memos to the court officer. I'll look at the memos and give the dates. Yes. Call the list.
Yeah, one matter. Your lordships, kindly.
With lords kindly.
Yesterday, your lordship disposed of matter without accepting the earlier concept of pay and recovery. I will argue in detail. The other high courts have already taken view that this even for amended act also the earlier judgments are.
The difficulty is everybody is after spending time again coming up, and that you should have done it yesterday.
I will.
Your lordship. Lordship, interim order was granted, my lordship.
Please give the memo, whatever is urgency.
But the payment
please write in the memo. I will look at the memo and assign the dates. So please don't make a mention.
Your lordship,
Page-wise
I make
adjournment.
one submission, your lordship. Lordship, the auction has been conducted already.
I will not hear any of it. Please write the urgency. I will look at it in the afternoon and I will assign
They
the
are
date.
issuing
Don't
sale
waste
certificate,
post
your
time,
lordship.
please. Yes.
Page-wise adjournment. List 1, page number 2, serial number 326. List number 2, page number 1, serial number 2, page number 2, serial number 328. Page number 3, serial number 9 to 14.
The list 2,
Page
serial number 7. Kindly short accommodation due to some personal inconvenience.
finally.
Some personal inconvenience, senior will not be able to attend, so short accommodation.
This is matter in the month of January. Yes.
Page number 3, serial number 9 to 14. Page number 4, serial number 15 to 21. Page number 5, serial number 20
List
to
number
25.
4, serial number 8, Your
She will call, you can wait. Yes.
List number 3,
For orders matters not, need not call.
Say for 11, my lord. Say for
list
11.
number 4,
Lord, serial number 1, my lord,
list,
petition became
Which
infructuous.
case?
Filed memo for which?
which
List
list,
number?
sir?
Serial number 1, my lord. List number 4,
Yes.
being spoken.
Matter based also.
Main matter is already disposed of.
It is a matter very well. No, ma'am. You find obtain the complete matters.
Understand what's going to the petition?
That is a the following.
Memo is filed. Seeking to withdraw the writ petition, it is stated that the main MC itself has been dismissed on 5/11/2025. No, apart from that,
Please.
in this matter, what order needs to be passed is, I have found fault with the officer who has not followed Rashish versus Neha, but he has followed. The detailed order is not placed before the court. I will record that,
Please.
and then I will
Please.
just keep it. We will see when the matter reaches. Yes.
Much obliged.
Lord, serial number 13, my lord.
Serial number?
List 4, serial number
4
13.
Yes.
List number 4, page wise adjournment. Page number 2, serial number 7 to 8.
serial number 8, Your Honor, due to personal inconvenience, praying for adjournment.
This is matter next Thursday.
Much obliged.
Yes. At the request of counsel for the petitioner. Yes.
Page number 3, serial number 9 to 15.
My lord, serial number 13, my lord. Short accommodation maybe.
Why?
Senior is out of station, my lord. Senior uncle is dead, my lord.
Have you informed the other side?
I have informed the others.
Yes, list in the month of December. Whoever want adjournment, have it in the month of January. Yes, January.
My lord, interim order granted may be extended.
Yes, interim order extended till then.
Great.
Yes.
List number 5, page number 3, serial number 8 to 13.
It's a list number 5 is at 2:30.
Yes.
Yes,
With my lord's kind permission, my lord, serial number 10, my lords, in list number 5, I seek for a short
List
accommodation
number
anytime
5 at
next week, my
2:30,
lords.
not now.
It's at 2:30, sir.
Yes.
The reason, my lords, that we have engaged the senior counsel is unavailable.
My lord,
Hello.
they informed me, my lord, saying that, my lord, the senior is not well, Mr. Holla, sir. And my
Mr.
lord, they
Udayavola is
my lord,
on
I
today, my lords.
Monday, in fact, I have to file my objections. I'll survey copy to other side. It's the same matter where
In all these DRT matters, senior counsel, for the sake of senior counsels.
since he's not well, it's in the
No,
senior
he's
advocate,
unwell
my lord. I don't
today,
have
my
it. Kindly have it on Monday, some
The
urgency.
difficulty of the court is, it's not about that. Every matter, if it is adjourned like that,
Since they
it's a
request-
burden on the court.
I understand.
Which is the title, which is
Serial
the
number 10,
Serial
my
number
lord.
10, my lords, 10 and 10.1.
There's an urgency.
Serial number 10 on Monday.
Grateful, my lord. I am permitted to file objections.
Interim order may kindly be extended, my lords. Interim order may kindly be extended, my lords.
Petitioner, interim order earlier granted is extended. Yes, call the.
Grateful, my lord.
List number
Please, my
1,
lords.
for disposal, serial number 1.
I appear for
Pass over, my lord.
No passover, item number 1.
My lord, senior is on the way.
Let him be. I will not pass over item number 1. You don't appear from the last 2 occasions before the court.
I am
When the
proxy
matter-
counsel, my lord.
Then you please inform him that the court is proceeding with the matter. If he
My
wants
lord,
to come, let
kindly,
him
he's
come.
on the way, my lord. Senior is on the way, my lord. Kindly pass it on.
Why he's not coming to the court when the matter is item number 1?
He's in other court hall, yes. Kindly pass on, my lord.
And I will call this matter at 11:20. If he doesn't turn up, I will dismiss it.
Please, my
Tell
lord.
him.
For order.
There is a limit for everything. Yes.
Serial number 2, for orders matter.
Petitioner, short accommodation.
1
1 week time.
Submission of.
What has happened to the earlier Shara?
Earlier, Shira has gone for third time.
Hmm?
Postal Shira as follows. Now, unknown.
What is it?
That
Returned as?
inquiry unknown.
First time?
First time also. It's insufficient address first time.
Hmm.
And
Give the file. Then why you have moved the memo?
Short accommodation one week. Matt, this suit is not maintained. Infractions.
What is that?
Infractions
Infractions.
matter. So 1 week time senior.
This is matter of service of notice. The process shall be paid within a week. Yes. 3.
Cell number 3. Hearing uninterrupted application, Dhananjay BC, Nirmala Krishna for
I
petition.
have compiled the court order, my lord.
Have you given to him?
Lordship.
Yes.
As per the court order, I have compiled, I have filed 50% of the 1,20,000 was the arrears, and at the rate of 5,000, I have paid on before the.
Yes.
And apart from that, I am also
Mr. Counsel, get instructions about compliance with the interim order.
Yes, madam.
Yes, this is matter on Thursday.
My lordship, the stay order, they have issued a NBW, and the stay order also is been okayed, my lordship.
By
Because
whom?
earlier, by this honorable court, because earlier it was not, my name is not listed, cost listed was not shown my name. So hence I could not appear.
Then whose name is shown?
It was earlier because I filed NOC Wakala. So hence it was a very difficult, my lordship. Kindly stay me with, because I have compiled the court order very long back, and also paying 5,000 per month, and they are not furnishing the account details.
Get
And also,
instructions. We'll take it up on Thursday. Yes.
till then,
We'll see on Thursday. Yes, 4.
Padmanabh Maila, petitioner, cell number 4.
Will issue notice 585 days delay. Notice to the respondent.
Cell number 5.
Emergent notice.
Petition, my lord. My lord, in this case, I may also be permitted to take on the trial court advocate, my lord, where the case is pending.
Execution is filed.
Yes, my lord, under CMS 125, 7 is fine. 3 is fine, my lord.
Execution.
Yes, my lord. Execution is
But notice to the respondent, in addition to that, when counsel for the petition is permitted to take out hand summons on the counsel appearing for the respondents in the execution case. Yes, 6.
grateful, my lord.
Petitioner in this case, Lord.
Yes.
The petitioner has filed an application petition under section 125 CRPC that has been dismissed by the first additional principal judge family court, Tumkur, Lord. The petitioner and the respondents are the residents of the same village. They developed
notice to the respondent.
List number 2. Cell number 1 for orders.
I approve. Appellate, my lord. The case on ECA, lordship.
Council submission.
Lordship, because that is regarding the amount of interest amount, your lordship. Interest amount has been compromised, and they have received the waiver of the interest and filing the joint memo by the claimants itself.
You have filed joint memo, my lord.
That?
Claimants, they are not, they have received the amount, full amount 15 lakhs have been deposited, your lordship.
15 lakh 12,000 without interest.
And
Where is
interest is
that?
challenging before this court, your lordship, as per the policy conditions. And in between, they approach to the company, they waive off the interest.
Mr. Ravi Shankar, please, it's listed for orders.
Yes,
What
sir.
is office objection?
That is the only, that is objection.
Council submission with regard to the production of original certificate.
Original
for-
certificate already filed, your lordship.
For depositing that's what I'm asking.
This is already, I filed your memo, kindly see the your lordship. Original memo, yeah. Memo is here, the lordship can see the original along with the appeal itself, I have filed. Deposit memo.
So now the whole issue is with regard to the interest.
Interest only, your lordship.
And you are ready to forego.
Please, ma'am.
Insurance company is only on the limited ground.
Yes, your lordship.
Yes, madam.
You have already received 15 lakh 12,000.
No, my lord.
Deposited before the
Deposited
WC.
before the
15 lakh
Yes,
12,000.
sir, that is the amount.
Please
Award
come.
amount.
The present appeal is filed. Agreed with order passed in ECA number 71 of 2024, dated 2nd July 2025. The insurance company is before this court. Then counsel appearing for the insurance company submits that the
You can
as
see
per
the
the award,
question of law, framed, your lord. That is the only question of law.
where do you get the interest component?
Lordship, policy has also, here,
In the
kindly see
order,
the, yes, policy.
order, where is the
Order.
interest part?
Jointly and severally has passed in the judgment, your lordship. Jointly and
What I'm
severally-
asking, where is it?
I will tell you. Component, interest component. So far as the awarding interest.
The
your lordship.
tribunal has awarded an amount
Para
of
26.
50 lakh 12,000 together with the interest at the rate of 12% per annum. The questioning that they filed this appeal, it is submitted that the insurance company is not liable to pay the interest.
Yes, sir.
Now, a joint memo is filed before this court stating that the claimants are ready to forego the interest and the insurance company has already deposited 15 lakh 12,000 before as per the memo, it says that they will deposit the amount of rupees 15 lakh 12,000 without interest within 30 days from the day, from this date in the court below. Now it is submitted that already that amount of 15 lakh 12,000 is deposited. In the light of the joint memo filed before the court, the appeal is allowed by setting aside the award as far as the interest is concerned.
Please, my lord, my acceptance of wakalat may be accepted, my lord. I filed wakalat on behalf of
Wakalat for R1 by Mr. N.R. Rangigowda is accepted.
And also protection of the minors also is a price of application. your lordship.
application.
He served the copy also that. Because 2 minors are there.
Mm.
Yeah, deposit already made by the trial court itself.
They're represented by the mother.
Yeah, already filed the memo here.
Please, my lord. Represented by their mother, natural guardian, my lord.
Yes.
Respondent number 1.
Mm. Yes. I number 3, where is that? I number 2 of 20, 1 of 25 is filed to condone the delay of 27 days in filing the appeal. Condone. Yes, next 2.
Much obliged.
What is that?
Much obliged, my lord.
In the light of the same, all the As are stands disposed. Yes.
IAP for the
Yes.
For case of death, my lord.
What is the age?
My lord, 34 years, my lord.
What is the income?
Income, my lord, he was
24
working as a
accident,
mason, 16,500, my lord.
Hmm?
16,500, 2024 accident, my lord.
2000?
24.
It should be 16,500.
500. Yes, my lord.
Quote are taken?
Taken, my lord, 15,750.
Huh?
15,750, my lord.
15,750. Then what about the multiplier
Multiplier 16.
is applied?
Yes.
Then future prospects
40%, my lord.
considered?
Yes, considered.
So now the only issue is with the
Only issue, my lord,
income.
insurance company also filed an appeal, my
15,700.
lord, challenging the only quantum.
you are also on quantum.
Yes.
So now let's do it.
Please, that's what.
So 16,500
Yes, 6,600, 40%.
plus 40% future prospect comes to
6,600.
6,600. Then it
23,100 is the total amount.
23,100. How many are the dependents?
Deduction
5, my
1/4.
lord, 1/4 the deduction, my lord.
1/4 is how much?
5,775.
Uh,
So 17,325 is the last of monthly.
into 12 into 16.
16.
33 lakh 26,400.
Yes.
33 lakhs.
26,400.
Then 5 into 44.
2 lakh 20,000.
36,000, 10,000.
Huh.
How much it's coming?
Like 35 lakh 89,400. As
Agreed.
against the award of
Against
37 lakh 16,631.
30?
7 lakh
7 lakh
16,631.
Now, when the court has taken this income at
what has happened, my lord,
Hmm.
under the convention, let's kindly see the
Oh.
under the convention act,
Yes.
filial consortium 2,50,000 and love and affection
Sir,
2,51,000.
love and
That is
affection,
how
my lord,
they have
2,50,000 is
awarded the compensation.
Hmm.
That's the reason it is. Funeral expenses,
Some amount.
filial consortium 2,53,335 and loss of love and affection 2,50,000. That is the reason, my lord, it is.
Please go. Agreed with
Notice to
award
ask-
passed in MBC number 6389 of 2024, dated 11 July 2025. Both the insurance company as well as the claimants are before this court. The claimant's appeal is MFA number 7956 of 2025. And the insurance company's appeal is MFA number 7654 of 2025. In this, the docket order is IA number 1 of 25 to condone the delay of 6 days, condone for the reasons stated in the accompanying affidavit. The claim petition was filed seeking compensation of an amount of rupees
Amount of rupees, my lord.
37 lakh 37 lakh 16,000.
50 lakhs.
50 lakhs,
50 lakhs.
Seeking compensation of an amount of rupees 50 lakhs for the death of the deceased in the accident. The tribunal has awarded the compensation as per the table given below at page 27, para 27. When counsel appearing for the claimant submits that when this accident had taken place in the year 2024, the court ought to have taken the income at 16,500. Instead of that, the court had taken 15,750 as the income and granted the compensation. It is submitted that on all the grounds, the compensation needs to be enhanced. Next para. When counsel appearing for the insurance company submits that the insurance company is agreed as far as the compensation that is awarded for the loss of filial consortium, loss of love and affection. It is submitted that is the amount that is awarded is contrary to the settled law. As such, the same needs to be reduced. Next para, having heard the counsels on either side, peruse the material on record. Considering the fact that this is an accident of 2024, this court is taking the income at 16,500. As he is aged 34 years, future prospects at 40% comes to 6,600. That is 23,100. As there are 5 claimants, 5 claimants, 1/5, 1/4 has to be deducted towards the personal expenses. That is 5,775. then his contribution to the family would be 17,325 into 12 into 16 is 33,26,400 towards loss of consortium. 5 into 44, 2,20,000. Funeral expenses 36,000, and the legal in the light of the law laid down in Mekala versus so and so, legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 35,89,400. Accordingly, the appeal of the claimant MFA 7956 of 2025 is dismissed, and the appeal of the insurance company.
No, partly. Partly allowed.
What is partly? Nothing is there.
Because income is increased.
Ultimately, it is about the result. MFA number 7654 of 2025 filed by the insurance company is partly allowed. Next, the amount in deposit shall be forthwith transferred. The enhanced amount shall carry 6%.
In his appeal, I may be directed to take notice. In my appeal, yes.
In 2, you are all, Mr. Shivanagoda is permitted to file wakalat within a week. And in 2.1, Mr. Nayak Krishna Venkatraman is permitted to file wakalat.
1 to 5. 6 notice may be dispensed.
For 6, sir. In 2.1, a memo is filed seeking dispensation of notice to respondent number 6 dispensed with.
Much.
Cell number 3.
Yes.
Raju CM for petitioner, appellant.
What is that? What is called now?
That's the serial number 3. CM Raju. That's notice.
No representation. This is matter next Thursday. Yes.
Cell number 4. Cell number 4. K. Shantraj. Manjula Tejas.
Ready?
Yes.
This case.
Seeking enhancement.
Yes.
Death or injury.
Death.
What is the age?
Age 40 years.
Which year is the accident?
This is he was working in a private company limited and drawing salary of rupees 33,000 and tribunal has taken 30,000
as income.
And he has added 25% future prospect instead of 50%.
How much future prospects?
50% has to be added.
Court has taken?
25%.
What is his age? 40.
Had crossed 40 years. He had crossed 40 years as per his Aadhaar, Your Lordship.
As per the?
His Aadhaar.
Not Aadhaar. It's a case of death. PM report is not there. PM, sir, as per that, what is the age? Please take Exhibit P8.
Yes, sir.
Exhibit P8.
They have shown us.
Record is not there. You have Exhibit P8, take that.
P8 and Exhibit P16 too. There are, he has examined the HR manager of the.
We will take Exhibit P8 because that is what we can consider P8.
P16 also.
When there is a dispute with where are different ages, different this thing, we have to consider the PM report.
We have produced the PAN card. In that, age is 40 years, 1 month.
So that is 40 plus.
Yes, sir. That's what my submission.
In respect of that, the Apex Court has been clarified.
Look at it and tell me what is the age as per the PM.
40 years they have mentioned. 40 years they have mentioned in the PM report. And as per the PAN card which they have produced, 40 years, 1 month and a few days, Your Lordship, 20 days. So he had crossed 40 years. Therefore, 25.
Please take the judgment.
Yes.
On page number 11 in para 14, you know.
Let's see what this judgment is relying on.
Honorable Justice Ramana and other 2 judges.
Yes.
After pronunciating the Lord's Fantasy,
But this runs contrary to the judgment, earlier judgment.
No, it is not contrary.
No, no, where from the, no, no, where from this 15%, 30%? It is only if it is, if it is the permanent employment, 50%. If not 40%, from the age of 40 to 50, 25, 50 to 60, 10. That's it.
Yeah. Earlier, before the Finalizing case in 2012, in Shashikala case, the Apex Court has held, relying upon the Sala Verma judgment. Sala Verma says 46 to 50 and 51 to 55. That should be the multiplier applicable. Therefore, this judgment has been clarified. He has not completed 41 years. This is also three judges bench judgment.
Yes.
He has not crossed 41 years.
40% is below 40 years. It is not necessary that he should cross 41.
Yes.
Below 40. That is, he should be 39. Once he is 40.
No, that is not the principle. Sala Verma says 41 to 46.
Yes.
41 to 45. 46 to 50. That is the Sala Verma judgment has been passed.
Pranay Sethi?
He is a permanent employee.
Pranay Sethi. What is Pranay Sethi?
Pranay Sethi, they say, yes, your expression is right. But they have relied upon the judgment thumb rule, which is thumb rule.
Yes, I understood your submission. Then now coming to where he is working.
Para number 13 of the judgment. In Vinayaka CNC Private Limited, he was working, Your Lordship.
It's a private company.
Yes, Your Lordship. Para 13 is the discussion regarding the income.
Deduction of 1/4 is correct?
Yes, Your Dependent.
Deduction of 1/4 is correct?
1/4 is correct.
Professional tax has not been.
How many are the dependents?
4. 4.
Dependency, loss of future prospects. 41.
Number submission, Your Lordship. Professional tax has not been deducted by the tribunal, Your Lordship. 200 rupees, as could be seen from their salary slips.
It has been deducted in the source itself. Question of deducting double.
What is that?
Professional tax of 200 rupees per month has not been deducted while taking into consideration the month.
Anyhow, no, we will not go into all this in his appeal.
Yes.
Now only his contention is, it should have been taken as 50%.
Yes, Your Lordship.
That is one aspect.
Yes, Your Lordship.
And the other one?
Income has to be taken at 33,000 per month.
Court has taken 30,000.
Yes, Your Lordship.
Why the court has taken 30,000?
They have taken average of 6 months. They have taken
31,836.
802, sir. Last month drawn salary before his death was 31,802, Your Lordship.
It can be taken as 31,831.
I have taken that 31,000 last drawn salary. I have taken as 31,802, deducted 200 rupees towards professional tax, as could be seen from the salaries documents. And I have done the calculation if my lord permits.
Pass on.
Yes, Your Lordship.
Adding 50%.
I'll not add. Take that.
It is so. The matter is
Calculation.
then bench. After deciding that matter, I will argue this.
Yes.
Yes.
This is marked in the month of January. Yes, next.
My lord, so on submission, my lord, previous matter I am.
How many times that
Sorry.
matter has to come and you don't appear before the court? It is very unfair.
Sorry, my lord.
Call that RPFC.
No,
No. What happened to that?
No representation on 13/11.
Huh?
On 13/11.
Take. Yes. I was thinking that RPFC is passed over.
sorry.
That you're referring to. Yes.
My lord, MEC case. She is not the daughter of the deceased, my lord. To prove relationship, she has filed her ration card. I am the driver of the vehicle, my lord. The owner's liability, my lord. And she filed the ration card, my lord. She has not produced any document to prove the relationship, my lord.
No. You are not the owner of the vehicle.
I am the my lord, claimant. I am owner, my lord. Owner and driver of the vehicle, my lord. Owner's liability, my lord, has been awarded amount.
Have you contested the matter before?
Please, my lord. And trial court, my lord, awarded, my lord, 10 lakh rupees. The claimant is not the daughter of the deceased, my lord.
How do you know?
She has filed only the ration card. She has filed to prove relationship. Kindly see, my lord.
No,
judgment.
your liability as far as accident has happened, that is that is not in dispute.
Not in dispute, my lord. I am a
Disputing the relationship. of the
relationship also,
deceased
my
with-
lord, and also I have acquitted in the criminal case, my lord. Also.
Oh, that is a different
Please, my lord.
aspect. Who are you to dispute the relationship? What is your problem about their relationship? Whether
No. She has no relatives, my lord. She alone, no, my lord. She has died.
Notice, will not grant stay in this on that ground.
Please, my lord. I will ready to pay, my lord.
There is nothing, if that is the ground, I will not interfere.
No, my lord.
Let the respondents come.
My lord, stay, my lord. Execution. They are approaching execution.
No, what it is, you say you are liable to pay the compensation.
Please, my lord.
But you say that she is not the daughter of the deceased. Who is the daughter then?
She has no, my lord. Nobody, my lord.
How do you know?
Please, my lord. In the judgment also, it is written in the judgment.
I am asking, how do you know? What is the relationship between you and the deceased? How do you know about the deceased, his family?
I am same village, my lord, residing in the same village. She says that no adopted daughter. She says that, my lord, she has taken adoption. Adoption did not produce it before the court. Even trial court also says in the judgment, my lord, reasons. On the basis of ration card, my lord, kindly see page, my lord, page 16.
Will not, please take notice.
Please, my lord, I am ready to pay, my lord, some amount if it is direct me to pay, my lord, deposit.
Some amount. No, what is to be decided by this court now? Accident happened because of your negligence. There is no dispute on that. Now, for the purpose of buying some time, this is what you are coming up before the court, saying that she is not the daughter.
I am ready to pay, my lord, some amount if you are court, my lord, order. Maybe, my lord.
Pay 75% of the amount, they will withdraw.
Please, my lord, 30%.
First of all, I'm not interested to grant stay, and that too general order is 50%. You say 30%.
Please, my lord, 50%.
It is submitted that the deceased has no, the claimant is not the daughter of the deceased. No evidence is produced before the court in support of the same. But still the tribunal has awarded the compensation. Considering the submission, he shall be stay on the condition that he shall deposit 50% of the amount within 4 weeks, and on such deposit they are entitled, the respondent is entitled to withdraw. Yes. Notice to the respondent.
Sale number 5. Rangegowda NR, line
I am for respondent, my lord.
Case of death or injury.
Case of injury.
Huh?
Injury. Lord, challenging.
Where is the table?
There is no table, my lord.
Where is your
Paragraph
synopsis?
26.
Hmm?
Synopsis, my lord, in page number 1 of the
Yes, what are the injuries?
injuries, my lord, the moderate traumatic brain injury.
How many fractures?
Fractures, my lord, fibula, right fibula fracture and temporal contusion with head injury, my lord, is suffered. Left in paragraph
Pain and suffering, another
of the judgment.
Pain and suffering 30,000.
another 20,000.
Please, my lord. In this matter, my lord, contributory negligence fixed diagnosis to the 20%, my lord.
That we will see later.
Please, please.
Medical expenses as it is.
Yes, for my lord. My lord, the trial court without.
How many days?
17 days.
17 days, 17.
Yes. Which year is the accident?
2020, my lord.
2011-2020.
What is the amount?
Amount, my lord,
Notional income?
14,500.
14,000?
500. They have claimed 20,000 rupees, but they have no income. They have claimed 20,000 per month.
According to the doctor, what is the disability?
Disability, my lord, 25%.
To the limb or the body?
Whole body, my lord.
What did the court take?
Court is not considered.
Nothing has been awarded towards the loss.
Let's read that paragraph.
Paragraph 18 of the judgment, my lord.
Paragraph 18.
Please.
Please read.
Lord, further, the petitioner has stated that.
Have you examined the doctor?
Yes, my lord. Stated that due to the accident, he is not able to do his earlier work and lost his income. Further, he has got to examine the consultant neurosurgeon at PW2, who had stated that the petitioner has sustained left frontotemporal and left parietal contusion, left ganigelo-caspular contusion, left temporal extradural hematoma, subdural hematoma, and cerebral edema. Currently, he has frequent headache, giddiness, and he has also complained of impaired memory and impaired intelligence. On examination, revealed that conscious patients with cognitive and memory defects. He walks with a limping. He has cross.
I think the disability that is that 25%, whoever has given that is not the same doctor.
Same doctor, he is not treated doctor.
It's a different doctor.
Different doctor.
Neurologist.
In his assessment, there is no mention about this. That's what is the court's finding. If you want to examine the doctor on this, I will remand the matter. Otherwise, we can't, basing on this, we cannot do any guesswork.
I will contact with my counterpart, my lord. I will go through the matter, my lord.
Or else, why don't he appear before the medical board?
Please, my lord.
That is better.
Please,
we will understand. The learned counsel for the appellant submits that the court had failed to grant any compensation on the head of loss of future income when the doctor had deposed that there is a 25% disability to the whole body. Then counsel appearing for the respondent insurance company submits that the doctor who has certified that he suffered 25%, the disability is not he was not examined, and the doctor who was examined has not assessed. In these circumstances, the claimant shall appear before which place? Medical board.
Medical board, my lord, Victoria Hospital.
Medical board, Victoria Hospital, on 26th November.
Please.
On 26th November, after examination, the report shall be sent to the Registrar Judicial. This order shall be communicated with the Registrar Judicial to the concerned. Yes. List this matter after the report is received. Yes, next.
Cell number 6, Shripad V. Shastri.
Case of death, no insurance, only no insurance, case of death. Two, they are served, respondent are served. On 2 points, appeal is filed. One is the accident is of the year 2020, 10,000 is considered instead of 14,500. And husband,
which year you said?
2020, my lord. 2/1/2020.
Instead of 14,500, how much was considered?
10,000 is considered.
10,000.
And second point is husband and the two major sons are the claimant. 50% deducted instead of 1/3. Is the only point.
Yes. What was the age?
My lord, age is, my lord, the 55 years. My lord. Agricultural milk vending and milk vending society's a certificate is also produced to prove her income. To show is a avocation. Sorry, my lord. Conventional law head is also seems to be lower side.
This was What is the multiplier?
It is 11, my lord. 11.
What is the age? 50?
55, my lord. 11 is adopted.
It's coming to 15,81,688. How much is awarded?
7,26,000 is the loss of dependency. Totally 7,98,000. My lord, one submission, another one submission. My lord, since this vehicle is a Tata vehicle and R2 was the driver. My lord, R1 and R2, since it is not insured, R1 and R2 is jointly and severally liable is to be, order is to be passed, my lord.
R1 is?
R1 is the owner, R2 is the driver. Actually, the person who R2 is the owner, but it is not in the RC. But R2 is ready to pay some amount. That is why R1, but liability is vested on the R1 owner. Since it's no insurance, but R1 and R2, my lord, pass the joint and several liability. My lord, the matter will be ended.
Please come. Agree for the award passed on LC number 73 and 13 of 2020, dated 23rd August 2021 by so and so. The claimant is before this court. The claim petition is filed seeking compensation of rupees 22,60,000 for the death of the deceased. It is the case that on 2/1/2020 about 5, when the wife of the claimant and mother of claimant numbers 2 and 3 was walking on the road along with her granddaughter. The driver of the Tata Sumo vehicle came from the opposite side by driving the same in a rash and negligent manner and dashed against the deceased. The tribunal, considering the income at 10,000, had granted the compensation as per the table given below. Extract paragraph number 21 table. When it comes to the liability, the respondent number 1 is owner of the offending Tata Sumo and respondent number 2 is the driver of the vehicle. The vehicle is not insured. And the driver has been charge sheeted, and it has been charge sheeted under the said offence. Hence, the court has held that the owner is liable to pay the compensation. Next para. The land counsel appearing for the claimant submits that the court ought to have taken, that the incident has taken place, accident had taken place in the year 2020, and the court had taken 10,000 income. Court ought to have taken 14,500 as the income. Further, it is submitted that both the driver and the owner are jointly and severally liable to pay the compensation. Under the conventional heads also, the amount that is awarded by the tribunal is not reasonable. Next para. Though notice is served on the respondents, no wakalat is filed on their behalf. Next. Having heard so and so, having heard the land counsel of petitioner, appellant peruse the material on record. This accident had taken place in the year 2020, hence taking the income at 14,500 and considering the age of 55, 10% future prospects would come to 1450. Then his salary is 15,950. As the wife is a claimant, 1/3 has to be deducted towards the personal expenses. It is come to 5316. Then the contribution to the family is 10,634 into 12 into 11 towards loss of dependency. They are entitled for 14,03,688 and towards loss of consortium 44 into 3, 1,32,000, 36,000 and 10,000. Altogether, the claimant is entitled for an amount of 15,81,688 accordingly. The bill of the claimant is partly allowed, enhancing the compensation from 7,91,000 to 15,81,688, which the respondent number 1 and 2 are jointly and separately liable to pay. Yes.
Cell number 8. 7 adjourned. 8.
I am for appellant. Insurance
Yes.
company challenging on the ground of quantum my lord. Case of injury.
Who appears to the respondent?
8 alla? I am for respondent.
Oh, where is that? Look at it. If there is a delay on condition, they are not entitled for. Yes, 8.
171 days delay in filing the
Hmm?
171 days.
In your case,
Big man.
in 8, 117 days still. It must have been condoned.
Condone.
Hmm. Not in your case, it is in the earlier case. Yes. Give the file. Yes, Pradeep.
Injury was
It's a case of injury. Come to the table.
Please. There is no table.
What are the injuries?
In synopsis, I have mentioned there is no table in that judgment.
No, it's there. Table is there at page 28.
Yes, ma'am.
Paragraph number 49 pair. It's there.
The
How many are the grievous injuries?
previous injury. 3 fractures. Ma'am.
3 fractures.
Three total.
Then another 10,000.
Please.
Their appeal is also there.
Then only insurance company appeal, they are not.
Only question in quantum.
So anyhow, you are on other grounds we have to reduce. So
Third
we'll
grounds is
increase.
concerned with that is
6,000. Yes. Then medical expense.
city has taken the notional income.
No, look at it, Pradeep. According to
That I note down.
3,51,269.
That as it is.
Attendant charges also as it is. Huh?
Attendant
Incidental.
charges will not 8 and incidental transportation 87,200 awarded.
What is the age of the boy?
12 years.
12 years.
He is a girl,
Girl.
aged about 12 years.
Girl.
And the disability is how much?
Disability, my lord, the MSCT has calculated like death case. 12,000,
7% to 28%. 7% to 28% disability.
How can it be?
That is doctor evidence.
Please, my lord, para 45 may kindly be seen. Para 45.
Hmm. Hmm.
The MSCT
Hmm.
has taken the income 12,500 and added 40% future prospects and awarded 18,90,000 as like the death case. The 28,
That's not the calculation.
Yes, it is. Explanation has been given at page 21 of the judgment. It is clear as per the guidelines of the Supreme Court of India.
Which case?
In 2 cases, one that is master that I will.
Then paraplegia cases.
It's a master Ayush and all Kajal case that can't be equated if every case.
National Insurance Company Limited versus Pranay Sethi and others.
Pranay Sethi, where is this calculation?
So that has been quoted and anyhow I need some time. I will go through the judgment.
That's coming up for final hearing.
What-
Yesterday also it came up.
Any next date and then next.
This is matter in the month of December. Yes, next matter.
Number 8, 9, cell number 9, R. Shashidhara.
Yes.
For appellant, S.V. Hegde.
Ready, my lord.
Yes.
Everything went of 219 by 2022, page number.
MBC?
219 by 22, madam. Page number 25.
Page number?
Page 25.
20.
Para 37. Injuries and para 38, next page.
What are the grievous injuries?
Yes, ma'am. 3 grievous injuries. Traumatic fracture of right tibia, medial malleoli, fracture of medial malleoli.
So another 30,000. Yes, 60,000. How many days he was in hospital?
17 days.
17
inpatient, madam. The
So
ward is only 15,000.
incidental expenses 17,000.
The income is considered as per the chart. But regarding disability, doctor assessed 32.
How many days he was in hospital?
17 days.
Then loss of income during laid up period. Which year is the accident?
2021.
Income is?
15,000.
15,000.
So 15 into 4, 60,000. Then medical bills,
As per the bills, madam,
23,500. And what is the evidence of the doctor with regard to
disability, madam, 32.56% to a limb, lower limb.
30?
32.56% towards lower limb, madam. Criminal taken 10%, madam. Now, the injured is aged about 18 years. As on the date of accident, madam. The 10% is very low, sir.
May I make a submission, madam?
No, whatever is the age, it is only 1/3 of it. 1/3 of it comes to what?
10.85%. It comes.
So we'll take 11. We'll take 11.
Criminal has taken 10, my lord.
Huh?
Criminal has taken 10.
We will take 11.
Yes, my lord. I'll leave it to your lordship.
Income is taken by the tribunal.
Income is same, 15,000.
Correct.
Yes, it is as per chart.
We can have it under the head of loss of amenities. Because he is 18 years, 1/3 will not become half.
No, madam. My submission is, madam, you sustained 3 fractures, madam. Tibia, malleoli, and also great toe, madam.
That's what, under the head of loss of amenities, we'll grant some more amount. But not,
May I request, madam, 15% disability needs to be. Because in engagement, yes.
My lord, 1/3 comes to 10.85%, my lord. Oh, your lordship is
no,
considering 11.
we'll take it that way only.
Yes, ma'am.
So 15,000 into 12, what is the
11.
multiplier?
Multiplier is 18, ma'am.
18 into 11 by 100. It comes to 3,56,400.
Yes, ma'am.
Now coming to amenities. What do you say?
Another 25-30,000 can be granted, madam.
That is anyhow will grant for that disability. Loss of discomfort and 10,000 court has granted. We'll grant 40,000. No, permanent disability, it is 5,18,400.
No, madam.
No, my lord, that's a.
Page number.
You said the 35.
3,24,000 as well.
Page number 28, madam. In page.
20?
In page 28, para 40 minutes. Up to para 40, next page is the access.
Where is the table? 46.
Yes, ma'am.
Chart.
No. Chart in the 46. Page number 30.
30, madam.
30 of the in page 30, madam.
It is 4,17,000.
Yes, ma'am.
That's the total, my lord.
That's what. So permanent disability is 3,24,000.
24,000.
So pain and suffering 60,000. Incidental expenses 17. Medical bills are 28,000.
28, as per the bills. Loss of income during treatment 4 months.
That I have granted for 4 months.
60,000. Amenities
40,000.
please.
It's coming to 5,71,400 against 4,17,000. Please come. Agreed with award passed in MBC number 219 of 2020, dated 3rd October 2023 by so-and-so. The claimant is before this court seeking enhancement of the compensation. The tribunal has awarded the compensation as per the table given below at paragraph number 46, extracted. When counsel appearing for the claimant submits that when the claimant had sustained 3 grievous injuries, the court and the head of pain and suffering has granted only 30,000. He was in hospital for 17 days. Court had granted 10,000. Further, for the loss of income during the later period, as considered only for 1 month, it is submitted that when the evidence of the doctor is his disability is 32.6, particularly considering the fact that he's aged about 18 years and it would have a lot of impact on his future life, or the court had failed to consider the same and had taken 10% as disability. Court ought to have taken the disability at 15%. And for the loss of amenities also, the amount that is awarded by the court is not reasonable. Next para. When counsel appearing for the insurance company submits that the court has granted a just and reasonable compensation. Next, having heard the counsels on either side, there is a material not record. Considering the 3 fracture injuries that are sustained and the head of pain and suffering, this court is granting 60,000. Incidental expenses 17,000. Coming to loss of income in the later period, 15 into 4, 60,000. Medical bills as it is. Coming to loss of future income, where whatever is the age of the deceased, limb disability is 32.6. We have to take 1/3 of the same. So it comes to 10.8. 10.85. And this code is calculated at 11%. So 15,000 into 12 into 18 into 11 by 100 is 3,56,400. Loss of amenities, considering the age of 18, this court is granting 40,000. In the light of the law laid down in Mekala so legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 5,71,400. Accordingly, the appeal is partly allowed, enhancing the compensation from 4,17,000 to 5,71,400. The enhanced amount shall carry 6% interest.
My lord, one submission. Age is 19, my lord.
90.
19.
Yes.
No
Yes,
problem.
next. How much delay? On condition? Yes. Next.
J. Kumar T. for appellant. Renuka HR.
Case of death, my lord, the claim petition was dismissed. Claim petition was dismissed, my lord. On the ground that, the reasoning that, my lord, there was no negligence on the part of the offending vehicle, my lord.
What is that? Why it is dismissed?
Clearly on the ground that there is no negligence on the part of the.
You have failed to prove the negligence. You have failed to prove the negligence.
Please, my lord.
Which paragraph?
Para number 11 onwards, my lord.
Para number?
11 onwards. 11 onwards.
Please read.
That in order to prove the contention of respondent, the respondent examined the driver by name Sri Ravi H as RW1. In his chief examination, he has deposed that he was driving BMTC bus bearing.
The charge sheet is filed against whom?
Against the driver of the offending vehicle, my lord. He was driving this vehicle on left side of road. The deceased came on his two-wheeler in a rash and negligent manner in opposite direction, diagonally from his left side towards extreme right side, and dashed at the front bumper of bus and caused the accident. As such, deceased himself is wholly and solely responsible for alleged accident. RW1 in his cross-examination deposed that there was a road work from last 4 years. The road width is about 30 feet. The motorcyclist came from opposite direction. Further, RW1 denied his rash and negligent driving of bus. Further, the respondent examined assistant traffic inspector by name Sons of as RW2. He has deposed that after the accident, he went near the place of accident and collected CCTV footages, and he has prepared sketch. And as per his investigation, the accident occurred only due to negligence on the part of driver, and there was no negligence on the part of the
driver of a BMTC bus. RW2 in his cross-examination deposed that he came to know about the accident at about 3:20 p.m. on 7/5/2020. At the same day, he went near the place of accident at about 4:30 p.m. Further, in his cross-examination deposed that when he went near the place of accident, bus and two-wheeler was not at the spot, and he has not witnessed the incident, and he has seen the CCTV footage.
This where is Renuka? Ask her to come, pass her, or else I'll pass orders to the afternoon. Yes. What happened to the password?
Passover, list one, serial number 1.
For the petition, my lord, because the client is not getting contact with me.
Then it's no problem.
No, my lord, the reason is I contacted the trial court advocate. The trial court advocate said that
We will pass orders on the merits of it.
No, my lord, last week he been admitted to the hospital for the reason. Kindly 1 week.
No, please tell the court, how are we concerned with his admission in the hospital? We will pass orders on the merits of it. Forget about the interim order.
Otherwise, because.
And why are you not appearing before the court from the last 2 occasions?
One week, my lord, kindly. I'll get the information.
You didn't answer to the court's query. Why are you not appearing before the court from the last 2 occasions?
No, my lord, I sent that my colleagues, my lord, juniors, because I didn't get that information. Morning, I was held up with the other court, my lord, for the
Not
reason.
morning, two times you are not there even before today.
But they have forgotten, my lord, because I instructed to my juniors.
How many times we should accommodate you? There should be some reasonableness on the.
One time.
There is no
Before
representation on behalf of the
Before
petitioner.
last time, I was unable to.
This is going on from 4/11.
Kindly, my lord. 1 week.
No, 1 week. I will pass orders on the merits of the matter.
No, my lord, because I contacted to trial court advocate, he seconded me, my lord, for the reason, my lord. Almost 30% already earlier he was being paid. That 30%.
No, I am not. I
20,000
am not.
is paid.
1 minute. I am not saying anything on the interim order. For arguing on the main matter, why do you require instructions from the client? Client's admission in the hospital has no impact on this because you have to argue the matter.
No, my lord, for the reason, because he is working in coffee estate together, that order not been complained, my lord, for the reason because they are.
I am not concerned with the order, interim order. I will hear the main RPFC. Forget about the interim order complaints. You argue on the main matter. We'll not go into that. Yes.
Two more copies are there, my lord.
Huh?
Because I required that 2 copies because disability it is there with that client for the reason, my lord. If I get that copy so that I can argue for the reason.
You should have done it. You should have done it while the criminal miscellaneous is pending. You can't do it all before this court in RPFC, and I will not take any of the documents on record.
I'll be ready with that. Any short.
I will adjourn it on costs of 2,000.
Because he's.
You're just taking the court for granted. And coming up with this kind of request.
Afternoon.
Yes.
Get the instruction. I'll do it.
Afternoon.
Please, madam.
Call this matter at 2:30.
Public.
Yes, next.
List 211.
Yes.
Paying for the appellate.
I am for respondent, my lord.
It's a case of death or injury.
Injury.
Please come to the table.
14 days of inpatient.
Huh?
14 days of inpatient. And aged about.
Come to the table. Where is the table?
Table is not.
No table.
Not table.
Come to the synopsis then. What are the grievous injuries? How many are the grievous injuries?
Two grievous injuries.
So then the court has rightly granted
Fracture
50.
of 6 vertebra and 40,000.
Yes, 50,000 is sufficient for the pain and suffering.
Yes, ma'am.
Medical bills as it is 1,69,699.
Future medical expense 35.
That we will take later. How many days was in hospital?
14 days.
days.
Madam. 1/4.
Incidental expenses 14. Yes. Then
Financial charges.
loss of income during later period.
Is not awarded.
No, what is this head diet and what is this head diet and nourishment charges? And nourishment and attendant charges all put together 25 plus 2. You are in a hospital for 14 days.
Yes, ma'am.
So how much the court has granted now? 25 plus 27.
27,000 award.
So let's take it, 25 plus
During
2,
the later period is not awarded.
27,800. Okay, 27,800. Then loss of income during later period?
Is not awarded, madam, because of PWTO, it is a doctor assessed with the disability of 20% of whole body, but he is not.
1 minute. Which year is the accident?
19, madam, 2019.
14,000. Will grant for 4 months. Hmm, 56,000. What is according to the doctor, what is the disability?
20% of the whole body. 20%
Hmm?
of the whole body is assessed there.
Limb disability?
Madam,
It's a head injury.
is a sixth vertebra, madam.
So what is the limb disability?
Is only assessed 20% of the whole body.
Court had taken?
Not given particular limb or is directly is assessed a disability 20% whole body. Is not given any.
Because as far as the vertebra is concerned, there cannot, you can't consider it as a limb disability.
Please, madam, my one submission, madam.
Hmm.
Judgment page number 12, my lordship.
Hmm.
Para number 13, my lordship, bottom line. He is not in a position to do hard labor work and he is assessed disability injury 20%.
No, where are you reading?
Judgment page number 12.
Paragraph?
Paragraph 4, my lordship. He is not positioned to do
Hard
hard
labor
work.
work.
He is assessed disability injury 20% of the whole body. Is relevant to point as per the evidence of the PW1 examined petitioner on 9/11/2021 and PW2 is complained before him the deformities he was suffering. The deformity expressed by the PW2 are not spoken by PW2. That part of PW2 is admittedly not issued a separate disability certificate assessing permanent
How much
disability.
the court has taken?
Court is not considered because
Not
of
considered, madam.
On the ground?
Is not produced a separate disability certificate, but doctor is examined. Assessed 20% of whole body, but he is not produced the separate disability certificate. This is the contention is tribunal is not award the loss of future income and.
We will take some percentage. So
Yes,
remaining the
madam.
what?
maybe my lordship may be taken 7 or 8%.
10 we will take.
10%, madam.
Because
So
they
which
have
will-
admitted my lordship in cross examination.
So 14,000 into 12 into what is the multiplier?
Multiplier.
15, my lord.
Huh?
15.
It's coming to 2,52,000. Loss of amenities. So what I'll do is, this loss of income during the later period, instead of what court has granted, I will grant you, how many days he was in hospital?
14 days.
14 days.
So I will make it 14,000.
Please, ma'am.
So loss of amenities, how much is granted?
Not granted, madam. Not awarded before the tribunal.
No, you have written something in the synopsis.
Only convenience charges.
Future
and
medical, oh, nothing is granted.
nothing.
So loss of amenities 30,000. Future medical expenses as it is.
35,000 awarded.
35.
Please, ma'am.
As it is will take.
Please.
Legal expenses 10,000. It's coming to 6,16,699. How much is awarded?
3,02,499.
3,02,004.
499. Yes, please come. Agreed with award passed in MBC number 122 of 2020 dated 24th May 2022. The claimant is before this court seeking an dated by so and so. The claimant is before this court seeking enhancement of the compensation. The claim petition is filed seeking compensation of an amount of rupees 20 lakhs. The tribunal has awarded the compensation as per the table given below. It is there in the synopsis, not in the judgment. When counsel appearing for the claimant submits that when it is evidence to the doctor that the claimant has sustained 20% disability, the court has not granted any amount. It is submitted that even under the other heads also, the amount that is awarded by the tribunal is not just and reasonable. Then counsel appearing for the appellate insurance company submits that the tribunal has not considered the evidence of the doctor as he is not the treated doctor.
He is not treated.
As he is not the
He is
treated
not
doctor.
given separate disability.
And he has not given the separate disability certificate. It is submitted that when the claimant is there in hospital for 14 days, court had granted almost 28,000 towards pain and suffering, which is on the higher side. It is submitted that there are no grounds to interfere. There are no grounds to enhance the compensation. Next, having got the counsels on either side, there is a material not record. The tribunal, under the heads of pain and suffering, medical expenses, and future medical expenses, has granted a reasonable amount. No interference is called for. Coming to the incidental expenses, as rightly argued by the counsel for the appellate, when he was in hospital for 14 days, court had granted an exorbitant amount. Hence, this court is reducing it to 14,000. Then coming to the loss of income during the later period, for 4 months, 14,000 into 4, 56,000, this court is granting. Coming to the loss of future income, just because the doctor is not a treated doctor, that itself cannot be a ground for the court not to consider the disability, considering the evidence of the doctor and under the facts and circumstances. This court is inclined to take the disability at 10%. 14,000 into 12 into 15 into 10 by 100 is 2,52,000. Loss of amenities 30,000. The legal expenses in the light of the law laid down in Mekala versus 10,000. Altogether, the claimant is entitled for 6,16,699. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 3,02,499 to 6,06,699. Enhanced amount shall carry any delay 787 days, not entitled for the interest. Yes, next.
Pushmita ji.
I am for responding.
P. Pradeep.
My lord, in this case, appear for the appellant, my lord.
Yes.
Well, my lord, there's slight inconvenience today, my lord. Kindly next week, any date may be given, please, my lord.
This is matter in the month of January.
Cell number
Yes,
13.
much obliged, my lord.
13. Girish B. Baldare, appearing for the appellate, my lord. Case of injury.
Yes, give
Injury
it.
sustained.
1 minute. Where is the table?
Injury sustained with the petitioner. Fracture of right table to which
Table is at paragraph 30. What are the injuries? How many grievous injuries?
3 injuries, my lord.
60. So no enhancement is called for. Medical expenses as it is. Then how many days was in hospital?
73 days of inpatient, madam.
Incidental expenses 73,000. Then loss of future income, how? Loss of income during later period.
He was inpatient for 2.5 months. He was inpatient for 2.5 months. 4 months maybe considered.
No, because it's already in normal cases we are granting 4 months.
5
In this
months.
case, we'll grant 6 months. So loss of which year is the accident?
2020, madam.
20. 14,500 into 6. Comes to 87,000. Then now coming to the disability.
Which doctor has
According to the
stated
doctor?
40% of the limb, 15% has been taken.
Taken the
How much?
tribunal.
40% of the limb, 15% of the whole body, 15% has been considered.
So 1/3 of
1/3 would be even less.
So 40. So as it is.
As is.
Loss of future income. Is 4,32,000. Then amenities.
20,000 is awarded to tribunal, man, only
Another
20,000.
20,000. It's coming to 9,758.
Well, one submission, my lord.
It is can be 9 lakhs.
Contributory negligence.
No. 1 minute. It comes to 9,756. Contributory negligence is
20% fixed on
20.
the
20%.
yes, my lord.
On what ground? Are you contesting on that?
Yes, my lord. The petitioner parked the lorry on the left side of the road. And the offending vehicle come to the opposite direction, rash and negligent, dashed the lorry, my lord.
Let's read. Let's read that.
Paragraph
see the-
18, 18 and 19.
Please read.
I have perused the measure and sketch of the accident took place. It discloses that the lorry bearing so-and-so was parked on the side of the Hiriyur Hosdurga road near Brahmagiri, and the car bearing number so-and-so was came on the same road from Hiriyur and dashed to the said lorry. If the driver of the said lorry had parked with signals and other indications, definitely the accident could be avoided. Though the said lorry was parked without any signal lights, but it was the duty
At
of
what
the
time it has happened? Time of the accident.
12:15 of AM, my lord. 12:15
in the night
in the night on the AM.
while it was raining.
Well, no contributory negligence.
No,
Please
there
come.
is contributory negligence, Mulad. If he had parked it, first of all, there is no provision for parking a lorry.
Oh, he's
the driver of that lorry.
He is the driver of the lorry, my lord.
And he was checking the diesel tank. The accident did not happen when direct hit to the petitioner has not happened. The car has hit the lorry and he has fallen down. He was checking the diesel tank, is their version.
He parked at the extreme left side, my lord.
Whatever it is, you have to. I was under the impression that you are for the car. You are driving the car.
But VW1 stated that in the cross examination, I installed the indicator, my lord.
Who said?
VW1, my lord.
That is your
That is his self-serving statement.
Please come. So in this, it is 20%.
Yes.
20. Yes. So you have to pay 7,20,648. 604. Please come. Agreed with award passed in MVC number 22 of 2022 dated 4 July 2024. The claimant is before this court seeking enhancement of the enhancement of the compensation as well as a contributory negligence that is fixed on the claimant. The case of the claimant is that On 2/10/2021, he was proceeding in a lorry from Chikmagalur towards RK Povachin at about 12:14 a.m. when the lorry was stopped at the left side of the road. The claimant and the lorry cleaner got down from the lorry and checking the diesel tank. At that time, the driver of the car came from the opposite direction in a rash and negligent manner with high speed and dashed against the front side bumper of the lorry, and also dashed to the petitioner as a dash to the claimant. As a result, he had sustained grievous injuries all over the body. The tribunal has awarded the compensation as per the table at paragraph number 30. When it comes to the liability, comes to the contributory negligence, the court has held that at the midnight, the vehicle is parked on the road without the parking lights on, and held that there is contributory negligence on the part of the claimant. Next paragraph. Land counsel appearing with the claimant submits that there is no contributory negligence on the part of the claimant, and in fact, the parking lights were on. It is submitted that the tribunal has failed to grant the reasonable compensation. When he was in hospital for 73 days, the court has granted only an amount of rupees 35,000 under the incidental expenses, and under the head of loss of income during the later period also, the amount that is awarded by the tribunal is not reasonable. It is submitted that under the head of loss of amenities also, amount needs to be enhanced. It is submitted that on all counts, compensation needs to be enhanced, and there is no contributory negligence on the part of the claimant. Land counsel appearing for the appellant insurance company submits that the court had rightly held that there is contributory negligence. Respondent insurance company submits that the tribunal had rightly held that there is contributory negligence. At 12:05 a.m. in the morning, the claimant had parked the vehicle on the side of the road without the parking lights on. The court had rightly fixed the contributory negligence. And when it comes to the compensation, it is submitted that the court has granted a just and reasonable compensation. Next paragraph. Having heard the counsels on either side, the material non-account. As far as pain and suffering, medical expenses, and the loss of future income is concerned, court has granted a reasonable compensation. No interference is called for. Coming to the incidental expenses, considering 73 days of hospitalization, this court is granting 73,000. Coming to the loss of income during the later period, as he is already on hospital for 73 days, this court is considering 6 months, 14,500 into 6. The 87,000. Then coming to the loss of amenities, this court is granting 40,000. And in the light of so and so, legal expenses 10,000. And 10,000. Hence, the compensation is enhanced from 7,75,758 to 9,756. And as far as the liability of the insurance company is, it's 80%, and the insurance company is liable to pay 7,20,604. Yes, the enhanced amount shall carry 6% interest. Next.
14. Uday Kumar RL.
Claimant's appeal, my lord, I am for the appellant in 8201 and respondents in this one. Madam telling that she has not received the appeal memo of this, my appeal.
Even otherwise also, Lordship, in insurance company appeal, we only sought for pay and recovery order because he was not having a driving license.
He is for enhancement.
He is for enhancement, your Lordship. And on 2 counts, that is, it's a case of death, your Lordship. It's a case of death, your Lordship. Despite awarding towards loss of estate and funeral expenses, again the tribunal is awarded under 2 heads.
No, that's what we will make the calculation.
Yes.
My lord, that was, as far as income is concerned, he is a retired teacher, my lord, high school teacher. He was getting a pension, or wife itself, she has cross-examined 28,000 at 50% of the pension. Plus, he was an agriculturist. He is having produced the RTCs also. He was producing mulberry and also oregano. Mulberry, which was cocoons supplied to the Ramanagara, that market, that this one bank statements are also there.
How much is considered as income?
16,000 per
as per the
month.
Adalat, madam.
Student, 16,000 per
Exhibit
month.
P12, it's very clearly shows he has getting pension in 2021 itself 32,000 plus. Our wife is up in under deposition or cross exam, she tells 28,000, so now she is getting. Therefore, that should be considered, madam. In
28,000.
pension,
Why would we consider his pension as his income?
pension, 50% of pension is going to lose it.
What is the pension? 28,000.
No, 28,000, 50% she was getting after the death of her husband.
They have not.
Plus, he was agriculturist growing.
So 50% she's getting. So 14,000 more is what she's getting.
No, 28,000 as per 50%. That's what she's telling. 50% of the.
Any document to show the last drawn pension of that deceased.
That is not produced, but bank statement is there. In 2021 itself, he is getting 32,000. That's credit. That bank statement are there. It's clearly shows pension amount itself is shown.
Yes, we'll see this matter later. This is matter in the month of January.
And
Counsel for the appellate is the copy of the appeal memo. Yes.
Date may be given, madam. I will serve the copy.
Yes, list is not listed on 18th of December. Yes.
Then number 15.
Well, I am for appellant. There is another two cases connected matter is there. 8297 and 8321.
Where are they?
Here only. Here before your lordship, but it is not posted today. So
whatever is posted, that we will hear.
Well, that may be cause some inconvenience because there is a negligence aspect is also there. Tomorrow, Malad, I am not seeking for adjournment because there is.
Mr. Shastri, is the appeal filed by the insurance company or you?
No. It is, but it is not only for.
Payments.
Malad, it is not only for quantum. Quantum, if it is quantum, Malad, Monday I am ready. Today also I am ready. But Malad, other two matter that may cause some inconvenience.
Why it will cause whatever follows, whatever this judgment that will follow, give that, because it is not possible for the court to adjourn the matters again and again. Yes.
Malad, the liability is in question, Malad. Actually, I discussed with my learner friend. We both of us agreed to matter both these three matters is to be heard together. We are not intending to take any adjournment, Malad. Just to, if any confusion,
This is matter in the month of February. Next.
Malad, I am ready, Malad. I am ready, Malad. I am ready.
You're the file. Yes.
Malad, negligence aspect.
MVC 4178 of 21, Malad.
4178.
Well, negligence is on page number 9 and quantum is on 16, page number 16, my lord.
16. First we'll go to 16, then we will come to 19. Come to the quantum first.
My lord, quantum, my lord, these claimants are wife, minor son and mother, my lord.
So, which year is the accident?
2021, 15,000 is considered.
2021 is 15,000.
Yes, 2021, 15,000 is considered.
23/8/2021, date of accident.
So it is 15,000 as per the table.
Yes. On that point, 50% is added. I am not on that point, Malad. Since liability negligence aspect is deducted 50%.
Mr. Shastri, you're not on quantum?
Negligence, yes, my lord. In this case,
you're not on quantum. So, what is the amount that is granted? About 30 lakhs? 60,000?
32 lakhs, 25,000, my lord. And out of that, 50% is deducted.
That we will go. So, as far as quantum is concerned, nothing to be decided.
Yes, only negligence. That is why I am requesting, my lord.
Let's go. Let's read that. Which paragraph?
My lord, for issue number 1, my lord.
Yes.
Page number 9. Page number 9.
Read.
In the evidence affidavit, PW 123 stated that on 23/8/2021 at about 1 p.m. when Shahi Full riding Honda Activa scooter bearing number so and so by keeping Mariamma Khatan, Master Yasin, alias Yasin, and Samir on the pillar on Rayasandra Road near SGR apartment, Huskur Post, within the limits of Electronic City Police Station. Driver, goods lorry so and so drove the same negligently from opposite direction, dashed the same to the scooter, thereby caused accident. Caused injuries to Shaifullah, Mariamma, and Mariamma, that is Yasin, alias Yasin. Immediately after the accident, Shaifullah has been shifted to Blossom Hospital, wherein first aid was provided, then admitted to Nimans Hospital, wherein Shaifullah succumbed to the injuries. In the written statement, respondent number 1, insurance company denied the allegation regarding reason, mode of accident, and asserted that due to sole negligence of the driver of scooter, accident had taken place. In the cross-examination, PW1 stated that the accident taken place between scooter and a lorry, and her husband was riding the scooter by keeping 2 children on the pillar. Minor, both are minor. PW1 denied the suggestion that the husband was not having driving license and due to negligence accident taken place. In the cross-examination of PW2 and PW3 submitted that they have not witnessed the accident. In the 2 affidavit filed by PW4, Dr. Avinash Parsati stated nothing regarding reason of mode of accident. In the evidence of RW1, officer of insurance company, her say a witness of the accident reiterated the same facts and narrated the written statement regarding so and so. Exhibit P1 is the copy of FIR and complaint pertaining to crime number so and so registered in Electronic City Police against the driver of the goods lorry bearing number so and so for having committed the offence punishable under section 279 so and so act regarding the accident taken place between a goods lorry number so and so and Honda Activa.
The police have filed the charge sheet against the deceased also.
For the triple rating, my lord. For triple rating, it is not relevant while deciding the question of negligence. My lord, the 50-50 negligence is foisted because the deceased may not have driving license, and there is the pillion ride, another extra pillion, which is a minor, is permitted in the motorcycle. 2 + 1 children is also permitted. Well, under these circumstances, the negligence, issue regarding the negligence is not properly decided.
What do you say? 50% is on the higher side.
As liability insurance company has been exonerated before MACT. Liability fixed is owner of the vehicle. You are exonerated before MACT, Malad.
Why? No permit.
Liability insurance company. Liability fixed is the owner of the vehicle. As on date of accident.
Yes. What do you say on that?
Permit violation. Pay and recovery.
When is it permit violation? Which year is the accident?
23/8/2021.
21. Malad, that issue is dealt with by the tribunal in.
No, pay and recovery will not apply.
We will apply 1/4/2022 before amendment. Before amendment, Malad.
Accident.
Please, Malad. 1/4/2022 has been amendment.
Amendment.
23/8/2020. Date of 23/8/2021.
Malad, may I submit, Malad, as far as amendment is concerned, if my lord permits, Malad, I want to make one submission.
Yes.
Well, as per section 149 clause 1, it is not deleted or altered. Well, because of these 149, 3 and 4, that is that gives a rise, gives a benefit to the insurance company to pay first and recovery right. Well, now since the liability of the insurance company is a statutory one, as far as third party is concerned, the legislature deleted that provision and 149 clause 1 is retained. What it shows is they now lost the pay and recovery right also. Because it's a statutory liability, it made it absolute. Because some other complication has arisen to these owners. Well, after seeing
to come. Short passer. Yes,
Cell number 6.
Otherwise, Monday, both 3 cases, only request, only I can. Other 2 cases is there. That's why
this matter and whatever other matters.
Sir, number sir, connected matters.
MF number
now 8321 of 2024 and 8297/24.
List on 19.
My lord, it is only my request, my lord. We are not a
Monday it
person.
is not possible. Monday, Tuesday, I am having DRT matters.
Okay. No,
Yes,
for
yes,
that,
next.
no, my lord, kindly, but we are not the advocates to seek the adjournment, my lord. We are always eagerly waiting for disposal.
16.
I have paper appellant, my lord.
I am for respondent, my lord.
Case of injury. My lord.
Where is the table?
Table, my lord. Page
Table,
number
judgment page number
15
15,
of
my
the
lord.
judgment, my lord.
Page number?
15, 1-5.
1-5.
Hmm.
Pain and suffering, only 15,000 is awarded, my lord.
1 minute. Paragraph number?
Paragraph number, my lord, 5. Last para.
Pain and suffering. What are the injuries?
My lord, injury is my lord, fracture of shaft of left humerus.
How many number?
2 grievous injury, head injury.
What do you say? 60?
50,000 rupees, my lord.
Next, medical expenses.
Medical expenses 6,70,000 as it is, my lord.
In that attendant also added. What are the medical expenses?
My lord, 6,70,000 medical evidence.
Where do you get that?
Oh.
In the discussion.
My lord.
Let's see. Because it has added that also, so there must be
Yes.
medical expenses are not that
My
amount.
lord, 11, page number 11.
6,49,412. We will take as it is. 49,412. How many days he was in
My
hospital?
lord,
15 days,
Yes.
ma'am. 1-5.
1-5.
Then incidental we will add separately.
Please, ma'am.
15,000. Then loss of income during laid up period.
Laid up period only 14,000, my lord. 7,000.
Where is this accident?
My lord, 2019, my lord.
14,000, my lord. As per
14,000.
Lokadala chart.
14,000 into 4.
4 months is higher side, my lordship, maybe 3 months, my lord.
Into 4. Insurance company should not bargain for this small amount for 56,000. Then
My lord, loss of future earnings, my lord.
loss of income during the laid up period and what is the evidence of the doctor? Loss of
Doctor, my lord, PW2, my lord, orthopedic, my lord, was examined, my lord. He was stated that disability, my lord, left upper limb 31% and whole body 11% disability. And another doctor, my lord, PW3, neurologist, my lord, he was stated, my lord, disability, my lord, 35% physical disability, total physical disability, my lord. The tribunal is taken only 15% disability, my lord, whole body.
only one doctor.
2 doctors, my lord.
Why you examine 2 doctors?
My lord, fracture of left of humerus. I have examined the doctor orthopedic, my lord. He was stated 31% upper limb and 11%.
31 is 31.
11%.
1 by 4.
11% whole body disability, my lord.
How can it be?
My lord, 2 doctors examined, my lord. 4 and above, my lord, tribunal is taken, my lord, 15%.
It comes to 8%. 8% is upper body disability. Then
PW3, neurologist, my lord, examined, my lord, he was
the limb disability according to him.
not a limb disability, physical disability stated, my lord, 35%.
They first stated basing on the injuries.
Can you see, my lord,
limb disability.
PW3 doctor evidence, my lord.
What did he say?
Doctor evidence, my lord. He was evaluated and CT brain sound, right frontotemporal subdural hematoma with frontal contusions and cerebral edema. He was operated and a right frontotemporal decomprehensive craniotomy with hematoma evaluation was performed on 5/9/2019. And also, my lord, cranioplasty surgery is done, my lord. Craniotomy and cranioplasty surgery, my lord, head injury. Yes, doctor is stated, my lord.
Disability to which part?
My lord, he was disability is according to he was ever since the discharge he was having the symptoms of headache, occasional memory.
Orthopedic doctor has said about the head.
No, only orthopedic disability, my lord.
That is like 8%.
80%.
And then what about he?
Neurological doctor, my lord.
What he says?
He was stated a 35% physical disability, total physical disability 35%, my lord. Even it is a head injury, my lord. Yes.
Tribunal has considered?
Tribunal has considered only 15% over and above doctors.
What is the cross-examination of the doctor?
Cross-examination, my lord, is.
Why that is not believed by the court when the doctor said it is 35% whole body disability in view of the head injury?
I will make one submission, my lord, regarding disability, my lordship. Lordship may be granted 18% or 19% whole body. Lordship may be taken income as well.
One more submission, my lord. Kindly see the exhibit 12, my lord. Scan report, my lord. The scan report mentioned, my lord, yes, large subdural hematoma SDH at right frontotemporal region with periloneal edema, mass effect and midline shaft to left and other.
No, it is like this. There are two things.
My lord, undisplaced fracture of left.
The upper part, upper limb, it is 80% disability as per the doctor.
Yes.
Now what we have to take for the head injury? Head injury, the doctor said 30%, and you couldn't elicit anything that why it is not deposing confidence in the mind of the court. How is it discussed? Why the court has not taken? Come to that paragraph.
The tribunal is disbelieve the evidence of the doctor PW3.
On what ground?
Yes, madam.
He was suffering from headache and other related problems. He has assessed moderate disability with 35%.
Madam, page number 14, second para. Page number 14 of the judgment, madam, second para. Even though PW2 had assessed disability to the whole body to the extent of 11% by assessing physical disability to upper limb at 31%, in his cross-examination admits that the fracture sustained by the petitioner is properly united. Further, PW3, though he assessed disability to same of 35%, his cross-examination has admitted that the petitioner got impaired subsequent to his discharge from the hospital. Further, PW3 is ignorant about the occupation of the petitioner. He did not depose about the
23%.
Like 20%, my lordship. My lordship may be 20.
Even if I take 20%, future prospects.
Yes.
40%.
My learned friend with conclusion that my lordship may be 20% there.
Then 40% future prospects we have to take if it is 20.
My submission, my lordship. Like 20%, my lordship, future prospect does not arise. It is my submission, my lordship.
You are happy with 20%?
20% plus future prospects, my lord. I will discuss it about.
Because the reasoning that is given by the court is not correct with regard to the neurologist's opinion. Court simply says will not take.
Neurologist opinion, my lord.
As per my submission, my lordship, maybe 20% may be taken.
I'll take 21% and grant future prospects. Please come. What is the age?
Is my lord 34 years, my lord. 16 multiplier.
Multiplier?
16, my lord. 16.
Comes to 7,90,272. Loss of amenities for how much is granted?
15,000.
Will grant 40,000. It's coming to 16 lakh 10,684 against 9 lakh
9,15,000.
15,000. Please come. Agreed with award passed in MSC number 863 of 2020, dated 2nd February 2024. The claimant is before this court seeking enhancement of the compensation. The claim petition is filed seeking compensation of an amount of rupees. How much?
50 lakhs, my lord.
50 lakhs for the injuries sustained by the claimant in the accident. The tribunal has awarded the compensation as per the table given below at paragraph number 5. It is a case of the claimant, and as per the medical evidence, that is paragraph number 16, 5, 16.5. It is a case of the claimant that the evidence of the doctor that the claimant met with an accident that took place on 28/8/2019. He was admitted to Victoria Hospital, Bangalore on 29/8/2019. He had sustained fracture of shaft of humerus head injury. He underwent internal fixation of left humerus and he was discharged from the hospital on 3/9/2019. He took follow-up treatment at Victoria Hospital. When the doctor examined the claimant on 21/7/2022, he complained of pain in left shoulder, difficulty to lift, weight over the head with left upper limb, combing, putting on clothes, difficulty to do his routine activities. On clinical examination, he found that there is a restriction of joint movements of left shoulder, difficulty ablution, lift weight over the head with left upper limb, power of left elbow 4/5, difficulty in combing and putting on clothes. The radiological examination shows fracture united with implants inside. The doctor has observed that the doctor has deposed that that is PW2 has deposed that he is having a physical disability at 31% and to the whole body 11%. And the petitioner has also examined another doctor, PW3. He stated that the claimant had sustained moderate head injury and left humerus fracture, as one was in a state of drowsiness at the time of admission to the hospital. He also complains about persisting headache. He improved neurologically. Hematoma evacuation was performed on 5/9/2019 and discharged from hospital on 11/9/2019. Again, he was readmitted to the hospital on 30/10/2019 for autologous bone flap carneoplasty, which was done on 1/11/2019. And he was discharged on 5/11/2019 with GCSE 4V5 MX and no fresh deficits. He was visiting the hospital since then as an outpatient, as he was suffering from headache and other related problems. He has assessed moderate disability with 35% and has calculated physical disability to an extent of 35%. In the cross-examination, he has denied that the injury sustained by the claimant was healed up before his admission to the hospital. He has admitted that after conducting surgery and subsequent to discharge from their hospital, the health condition of the claimant was improved. The court had observed that though PW2 has assessed the disability to the whole body, to the extent of 11% by assessing the physical disability to the upper limb at 31%. In the cross-examination, he stated that the fractures are united. Further, PW3, though he has assessed the disability to the tune of 35% in his cross-examination, the petitioner got improved subsequent to his discharge from the hospital. The court observes that PW3 is ignorant about the occupation of the claimant. He did not depose about the loss of working and earning capacity. Hence, the court had taken 15% to the whole body and granted the compensation. Learned counsel appearing for the appellant claimant submits that the court had failed to consider the evidence of the doctor, PW2, who has stated that the disability to the whole body is 11%, and PW3, that the whole body disability is 35%. It is submitted that without any basis, court had taken 15% as disability. Further, it is submitted that on the head of loss of income during the later period and at the head of loss of amenities, the amount that is awarded by the tribunal is not just and reasonable. Next paragraph. Learned counsel appearing for the insurance company submits that the court, the evidence of the doctor couldn't inspire confidence in the mind of the court, and the court, considering the overall circumstances, has rightly taken the disability at 15%, and there are no enhancement. No enhancement is called for. It is submitted that on all counts, the amount that is awarded is just and reasonable. Next, having heard so and so, there is a material on record. When he has sustained a head injury and also a grievous injury under the head of pain and suffering, the court had granted 15,000 and this court is granting 50,000. Medical expenses, no interference is called for. He was in hospital for 15 days, hence incidental expenses 15,000, this court is granting. Loss of income during the later period, 14,000 into 4, 56,000. Coming to the loss of future income. He has sustained two types of injuries. One is the head injury, one is to the injury to the upper limb. The doctors have deposed that 35% and 11%. The court had taken 15%. The reason that is given by the court for taking the disability at 15% is without any basis, considering the evidence of both the doctors and the disability that is sustained by the claimant. This court is taking 21% as a disability. As the accident had taken place in the year 2019, the income at 14,000, considering the age of
34 years.
34 years, 40% future prospects would come to 5,600. That is 19,600 into 12 into 16 into 21 by 100 is 7,90,272. Loss of amenities 40,000. In the light of the law laid down in so and so, legal expenses 10,000. Altogether, the claimant is entitled for an amount of 16,10,684. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 9,15,000 to 16,10,684. The enhanced amount shall carry 6% interest. Any delay?
213 days.
213 days. So and so days they are not entitled for. Yes, next.
Appear for the respondent in this case, madam. I filed an application for.
Yes, we'll hear. What is it?
In this case, records may be necessary because the tribunal has awarded 6 lakh and odd towards medical expenses.
What about IA number 3 of 25?
We have deployed 10 lakh. Out of that, you may permitted to withdraw 6 lakhs.
How much is deposited?
10 lakh and odd. 10 lakh.
10 lakhs.
What is the compensation granted?
But 19 lakh 81,000 is awarded by the trial court, madam.
19 lakh and
You are on the quantum.
quantum.
So why should it be? It will be less than half.
Because medical expense itself, it has been reimbursed by the insurer.
How much you deposited?
10 lakh 66,000.
Granted is 19 lakhs.
19 lakh 87,600.
50% along
The
with
IA number 3 of 25 is filed, seeking to withdraw the amount. The insurance company has already deposited 10,000, the 10 lakhs. The
66,000.
appellant, the respondent is at liberty to withdraw an amount of rupees 8 lakhs.
No, 6 lakh more because here we have a case more.
Not injuries.
Because loss of future earning capacity has been
7 lakhs, yes. After the amount is dispersed, the trial court should send the record.
6 lakh more.
Number 18.
Yes, please.
Because here loss of future earning capacity has been awarded. There is a.
Yes, next.
Number 18, FS Dabali, respondent.
Yes.
case of injury. My lord.
Where is the table?
Table, my lord, paragraph 23 of the judgment.
What are the injuries?
Injuries, my lord,
Number.
3, my lord, grievous injuries.
The court has already granted 60,000, no enhancement is called for.
Please.
Next.
Next, my lord,
How many days was in hospital?
9 days.
Already enough amount is granted.
Loss of immunities, my lord,
No, loss of income during later period.
please.
In this case, my main question is about disability.
That we will
Disability,
go,
my lord.
we'll go into that. Which year is the accident?
Accident, my lord, 17/10/2022.
It has taken my 15, that's proper.
2022.
Correct amount has been taken.
15.5.
Please.
15,500 into 3. It comes to 46,500. Then medical expenses. 8,871. So loss of future income. What is the evidence of the doctor?
My lord,
What is the evidence of the doctor?
evidence of the doctor, my lord, is assessed the disability 35.68 to the right upper limb and 11% to the whole body. My lord, then 42.38% to the right lower limb. And 42.38% to the right lower limb. And 21.19% to the whole body, my
How
lord.
much was taken?
Tribunal, my lord,
8,
considered only 18%.
1 minute.
Because he has sustained a fracture of clavicle.
One minute. Should be 23%.
Please.
Because of fracture of clavicle, he has assessed not 35.68% to the upper limb, which is not justified for fracture of clavicle bone.
My lord, you also suffered malleolus fracture and fracture of right ankle.
Please come to the discussion.
Para 21, my lord.
Come to that. Yes.
PW2 has reported that petitioner has permanent physical disability at 35.68% to the right upper limb and 11% to the whole body and 42.38% to the right lower limb and 21.19% to the whole body. Thus 32.19% is the total whole body disability. As per the judgment reported in so and so, the normal would be disability in the.
So without any basis, that is. Court said 26, we are taking
Please.
only 23%. We will take 23.
Here, fracture of clavicle bone.
That's not the finding of the court. How can you supplement with your argument?
No, by considering.
What is that court said? Please read it. Paragraph number 21. After the judgment.
To the whole body would be come to 26%, but not 32%. But taking into consideration the improvements found in the physical condition of the petitioner, which is evident from the evidence of PW2, this court is inclined to assess the disability at 18% because the tribunal is having more opportunity to see the condition of the claimant about sustaining of alleged disability. Because moreover, for fracture of clavicle bone, he has assessed disability.
Court has nowhere said what is assessed by the doctor is not correct. Court only said what would be the percentage if it is a lower limb, what would be the percentage if it is a upper limb. That's what it said. Nothing else. What we would do, 35.68 is to the upper limb.
Upper limb.
So we will take that would come to 9%. 42.38 is to the lower limb.
Please.
It comes to 14%.
14.
So 14 plus 9, 23. So what is the 15,500? What is his age?
Age, my lord, 42 years.
That means 25%.
Please.
It's coming to 19,375 into 12, into what is the multiplier?
14.
14.
14 into 23 by 100. It comes to 7,48,650. Loss of amenities 40,000. Legal expenses 10,000. It's coming to 9,34,021 against
5,88,591.
5,88,591. 590. Yes, please come. Agreed with the award passed in MSc number W192 of 2023 dated 4th November 2024. The claimant is before this court seeking enhancement of the compensation. The tribunal has granted the compensation as per the table given below at page 23. The evidence of the doctor PW2 is that he examined the claimant clinically, radiologically, and assessment of disability was done. That the claimant had suffered physical disability of the right upper limb at 35.68% and whole body at 11%, and 42.38% to the right lower limb, and 21.19% to the whole body. And altogether, he has suffered 32.19% disability to the whole body. The tribunal has considered the evidence, and at paragraph 21 of the judgment has observed that the doctor has deposed that the claimant has permanent physical disability at 35.68% to the lower upper limb and 11% to the whole body, and 42.38% to the right upper limb and 21.19% to the whole body, altogether 32.19%. And considering the judgment of this court, the court held that normal rule would be disability to the lower limb, 1/3 of the particular limb. Hence, permanent disability to the whole body would come to 26%, but not 32.19. But taking into consideration the improvements found in the physical condition of the claimant, which is evident from the evidence of PW2, the court has taken the disability at 18%. Next paragraph. When counsel appearing for the claimant submits that when the doctor evidence was considered, when the court comes to the conclusion that as per the same it would be 26%, why the court has taken 18% is not the award do not disclose the same. He submits that whatever is the present condition of the claimant, basing on that, the court had granted the doctor has deposed, and the court taking 18% is without any basis. Further, it is submitted that and towards a loss of income during the later period, further loss of income in the later period, the reasonable amount was not granted, and no amount is granted at the head of loss of amenities. It is submitted that on all grounds, then the compensation needs to be enhanced. Next paragraph. Then counsel appearing for the insurance company submits that the court, looking at the injuries that are sustained by the claimant and also assessing the evidence of the doctor, had rightly taken 18%, and there are no grounds to interfere. On all other counts also, the compensation that is awarded is just and reasonable, and no enhancement is called for. Next paragraph. Having heard the counsels on either side, peruse the material law record. According to the doctor, the disability to the upper limb is 35.68. Then, to the upper limb, it has to be 1/4 of the whole body disability. It comes to 11%. When to the lower limb, it is 42.38. 1/3 of it is 42.38 and 1/3 of it is 14%. So 14 plus 9 is 23%. Having considered the evidence of the doctor, the court just like that had taken the disability at 18% without any basis. And in the considered opinion of the court, there is no reason for the court to take the disability at 18%, but not at 23%. Hence, under the head of loss of future income, this court is taking 23% disability. As the accident had taken place in the year 2022, 15,500 and 40% future prospects would come, 25% future prospects, considering the age of
42 years.
42, it comes to 3875, and this income is 19,375 into 12 into 14 into 23 by 100 is 7,48,650. Loss of amenities 40,000, legal expenses in the light of so and so. Altogether, the claimant is entitled for 9,34,021. Accordingly, the appeal of the claimant is partly allowed by enhancing the amount from 5,88,591 to 9,34,021.
Much of that.
Enhanced amount shall carry 6% interest. It's next. No. We'll complete this list. Yes, 19.
Number 19, B13.
I am for appellant, my lord. Insurance company challenging on the ground of quantum, my lord. Case of injury, my lord. Aged about 13 years, my lord. Income taken 15,000.
You appear for this.
File index.
You can file after within a week.
I don't know. No, only yes, instructed.
This is matter in the month of December. Next 20.
Then number 20.
Of injury, mal.
Yes.
In this case, you are seeking enhancement only under the head of amenities, attendance charges, and future medical expenses.
Please come to that.
Blood.
Where is the table?
This is blood.
Table.
Table. There is no table, madam.
MACT has not done that.
Synopsis.
Synopsis, madam.
So you're seeking, how many days he was in hospital?
He was inpatient for a period of 6 days. 6 days, madam.
Then why you want enhancement?
He is a government employee.
Huh?
Government employee, government teacher, madam. He has suffered permanent disability.
No.
As per the doctor evidence.
You are saying you are seeking enhancement on the incidental expenses. When you are in hospital for 6 days, why should there be enhancement? That's what I'm asking.
Can you see the para number 10 of the appeal memo?
General rule is that basing on your hospitalization, the court will grant the incidental expenses.
But
whatever is the number, accordingly it will be granted.
But doctors stated disability, my lord. But
that we will go. Disability means that will you will get under the head of loss of future income.
But he as a government employee, he has suffered permanent disability. But the court awarded only 50,000 under the head of amenities. Can you see the para number 10 of the appeal
I am
memo?
on incidental expenses. You are not on that.
Please.
Yes, 60,000 and incidental expenses.
Only 1,40,000.
1 minute.
44,700 is awarded.
Expenses 24,700. So what is the disability according to the doctor?
According to doctor, madam, lower limb but 53%, whole body at 26%. Lower limb but 53%, whole body at 26%.
Already 50,000 is awarded. Loss of amenities.
Please, madam.
What do you say?
That is
because any loss of future income is not granted.
Another 50,000 because you have continued.
Madam, kindly see the evidence of doctor, madam.
Now, when your future income is not affected by this.
Okay, madam, but he is suffering permanent disability, madam.
That's why 1 lakh we are granting under the head of.
It is also lower, madam.
How much it should be? as it will be in case of loss of future income.
That aspect is not considered by the tribunal at all, my lord.
What?
That.
Are you working or have you resigned?
My lord, he has suffered totally, he has amputation leg, my lord. That's why.
Leg is amputated.
Please, my lord, kindly see the evidence of doctor. I have.
No, he has suffered a foot drop
Foot
and
drop.
he needs assistance only to the ankle, not amputation, my lord. The disability would come to 18% if the 1/3 is taken.
The doctor examined as PW2 clearly stated.
He
in
admits he is
evidence
not
that
a
patient
treated
always requires where splint to his right leg. Without splint, he cannot do any physical activities on his right leg.
So according to you, how much it should be?
This is permanent in nature, madam.
I'm asking you a question. How much amount according to you is entitled?
More than 5 lakhs, madam. As per Dr. Denson.
Doctor said so, he require.
But he requires lifelong treatment, madam, for attendance charges.
What does it mean? Splint means?
Drop.
Foot drop. The foot will not without the support of the some. So that the doctor has suggested you have to wear that and they can do it. And the thing is, he has continued in the job as a government teacher and he's teaching. Only I don't know why, but to that extent, there's some difficulty which may be faced by him in life, but not to the extent what my learned friend is portraying.
But also doctor suggested that he needs attendant throughout his lifetime.
Where did he say?
Para number, say, page number 4. Madam.
That's what the doctor said.
Correct, but the fact is that he has continued in this, and he has, in fact, there's an increase in salary. As far as his professional activities concerned, there's no.
That's why
I told that some amount under the amenities can be considered.
Only
I'm not on
50,000
that,
is very
not
lesser,
belittling
madam.
the injuries. His doctor is not a treated.
Oh, loss of future income is not there. That's why the court has not granted.
Yes, yes.
But this disability is going to have
Yeah,
an
that's
impact
true.
throughout his life. It's not as, like he says he cannot do his work and he requires an attendant all the time.
Some reasonable amount can suggest.
What is his age?
40 years as at the date of accident. Now he has 41.
No, 43 years.
Will grant 5 lakhs.
5 lakhs he would not. I think another 3 lakhs would be suffice.
For attendant charges only, it takes
Attendant
more.
charges on what? He has to only to help him to wear that and all. He can walk and he is discharging his duties. Otherwise, if we if what my learned friend was portraying,
His
then
age is
he
what?
could not have
40?
continued in job.
40?
41 years.
41 years. And he is drawing a salary of 70,000 as after the accident.
He is getting higher salary.
A higher salary. So if that had impacted his functional disability, it would have really adversely affected his. To that extent, he is saved. And fortunately for him, he has recovered. Not to the extent which the normal person would have recovered.
Cannot do any.
There is a
manual
substantial.
or daily activities. Madam. He cannot do any manual work.
And he is
daily
not
activities.
a treated doctor, and he gives a percentage of disability contrary. It should be 18%. 53 and 53, and he says 26%.
Will grant 5 lakhs. Please come. It's coming to 6,04,700. Agreed to the order passed in MVC about passed in MVC number 4713 of 2022 dated 30th October 2024. The claimant is before this court seeking enhancement of the compensation. The claimant is working as a school teacher, and as per the evidence of the doctor, there is a soft tissue injury with muscle loss over peroneal compartment, right leg with fractured neck of fibula with foot drop, within brackets severe right common peroneal motor axonal neuropathy. He underwent surgeries in the form of debridement and secondary closure under LEA on 30/4/2022. There is, according to the doctor, there is pain and difficulty in walking, inability to dorsiflex right foot, inability to work as a teacher. On examination, he is walking with limping with rigid right-sided foot drop gait, GAIT, within brackets, foot drop splint inside. Wasting of right lower limb is seen. Surgical and secondary scars are seen over right leg. The doctor opined that the patient always requires to wear splint to his right leg. Without splint, he cannot do any physical activity on his right leg. There is no sensation in right leg fingers in spite of wearing splint. If splint is removed, there is foot drop. According to the doctor, his total disability is 47.7%.
53, my lord. Lower limb at 53.
Then common peroneal nerve nanopathy is 5%. And to the whole body, it is 26%. And the doctor has also stated that after retirement, the patient cannot do any manual labor work. He needs an attendant throughout his life to attend his daily living activities, and the disability is permanent. He needs surgery in the form of tendon transfers, which would cost rupees 50,000 in a private setup. Then counsel appearing for the appellant submits that on the head of loss of amenities, the amount that is awarded by the tribunal is not just and reasonable. It is submitted that as per the evidence of the doctor, the disability would have an impact throughout his life, and just because he's continuing with the doctor, continuing with his profession as a teacher, that doesn't mean that he's not entitled for the loss of amenities. As per the evidence of the doctor, he needs an attendant. Hence, he submitted that on the head of loss of amenities, the amount may be enhanced. Next para. Land counsel appearing for the respondent insurance company submits that the court has already granted 50,000 on the head of loss of amenities, and he is continuing as a teacher. That itself shows that there is no difficulty for the petitioner to continue, for the appellant claimant to continue his profession, and the doctor who has assessed the disability is not the treated doctor, and the court had rightly granted the compensation. No enhancement is called for. Next part. Having heard the counsels on either side, there is a material on record. This court has perused the evidence of the doctor, which is extracted in the preceding paragraphs. This makes it very clear that what is the impact of the food drop on the life of the claimant. As he is continuing with the job, he is not entitled for any future loss of income, but this injury will have an impact lifelong, and the court tribunal ought to have quantified the amount under the head of loss of amenities, considering all these aspects. And further, when the doctor said there is implant inside and that the same has to be removed, no amount is granted under the head of loss of the expenses for the future operation. Hence, under the head of loss of amenities, this code is granting 5 lakhs and future operation 40,000. Legal expenses in the light of the law laid down so and so 10,000 and other expenses this court is not interfering with. Altogether, the claimant is entitled for an amount of rupees 6,44,700. Accordingly, the appeal is partly allowed, enhancing the compensation from 1,44,700 to 6,44,700. The enhanced amount shall carry 6% interest. 190? 190 days, he is not entitled for the interest.
Till number 21.
Appear for appellant Millet, case of injury Millet. Table is at 18 Millet, page 18 Millet.
18.
For 29.
Yes, what are the injuries?
Injuries are fracture of both bones of leg Millet. He was admitted for the hospital for 86 days Millet.
Pain and suffering 75,000 is fine.
86 days he was attended.
Attendant charges and all, it is already reasonably granted 93,000.
86 said he was in the hospital.
6,000. If you want, I will reduce it.
Amenities is lower side.
Let's see, incidental expenses 93,000. Medical expenses 5,900.
Loss of future earning
One
and
minute.
please. Interchange with in the table.
What about what is the disability and then loss of income during laid up period?
Laid up period 6 months melody. Interchange in the
3
table.
and 4.
6 months as awarded.
Loss of income during laid up period. It's actually it should be 4, my lord. It's vice versa, my lord.
Already awarded.
Once they have granted 93,000, but it's shown in underhead attendant charges.
Oh.
Interchange
So
in the
loss
table.
No, 1 minute. Loss of income 93,000. How many days he was in hospital?
86 days.
So then 86,000 will grant.
25 days as per the trial court. This
No. 86
where
as
you get
per
that?
doctor and also discharge summary 86 days melody.
I will take these 2-3 matters afternoon. So call the other list.
Yes.
No.
List number 3.
22 and 23 after 230 list.
21.
Matter also.
After placement.
Number 3.
Keep this in this file. Yes.
Number 3. For orders matter, serial number 1, Prithviraj BN.
Well, all these matters have to go before division bench. The insurance company has also filed an appeal in MFA.
That's what the memo filed.
1783.
It is submitted that the connected matters, that is MFA number?
6422. All the listed and in pending before division benches.
That is what is pending before division bench?
1783 of 2020.
1783 of 2020. 2020. That is filed by the insurance company is pending before the division bench. Registry is directed to list this matter along with that. These 2 matters, 3 matters along with that. Yes.
Serial number 2.
A week's time default order.
Let's TSRTC Millet.
Mr. Jabari is directed to take notice on behalf of the insurance company. Oh, there's only one response. Admit post of final hearing TCR.
Serial number 3.
Yes.
Serial number 3.
Notice. Oh, no, notice to the respondent. Next 4.
Serial number 4. Serial
No.
number 4.
Lord, I appear for the appellant, my lord. What has happened in this case is there's a division bench case pending before one case pending before division bench where the stay has been granted, and in this case I'll take steps, my lord.
Yes. A week's time.
Yes, my lord.
Yes.
Serial number 5. K. Prasanna Shetty.
My lords, we'll
So
file
the
a
copies
copy.
on the other side?
We'll serve it today, sir. The copy is
Yes.
ready.
I number 1/24 is filed to condone the delay of 330 days, condone on condition. Admit final hearing TCR 6.
Serial number 6. Syed Abdul Sabur.
A week's time default order.
All
Next.
please to him.
No, leave it. Next 7.
For appellant, this needful is done. Process is paid.
It is submitted that the process is already paid. Yes, next.
Serial number 8.
Here for the appellant. Remedy assurance.
Huh?
Remedy assurance.
Who appears for the New India Insurance Company?
New India Assurance.
Yes, Mr. Is directed to take, Ashok and Patil is directed to take notice. I number 1025, 344 days unknown. Admit final hearing TCR. Yes, 9. National Insurance Company. Who appears for National Insurance Company?
I take notice, madam.
Mr.
Rajendra Hegde.
Huh?
Rajendra Hegde.
So and so is directed to take notice on behalf of the insurance company. I have 1 of 25 to condone the delay of 45 days condoned. Admit final hearing. Next.
I'm appealing for the appellant, my lords. Needful done, my lords.
Who is R2?
Reliance. Reliance.
Reliance, you appear. Mr. Pradeep is directed to take notice on behalf of the insurance company. Admit, there is a delay of 252 days on condition. Admit final hearing TCR. Serve the papers. In all that to serve the papers. Yes, next.
Srinivasan MY.
My lord, I received the papers, my lord.
Yes.
Be granted to
Admit
file.
final hearing TCR.
Cell number 12. R2 Liberty R3 is going.
No, 1 minute. Memo to have, yes. 12.
Cell number 12.
List after service of notice. 13 also.
13.
After service of notice. 14.
Please, madam.
Request
Pray for
double.
2 weeks time, order.
Why 2 weeks?
No such person it has been done.
A 2 weeks default order. Yes,
Number
next.
15.
15. No representation. List this matter after 2 weeks. 16.
16. P. Vijay Kumar.
A week's time default order. 17.
17.
Press week's time, my lord.
A week's time default order. 18.
Number 18.
Awaiting service, your lordship.
Yes, list after service of notice.
Cell number 19.
List after service.
Cell number 20.
20 also list after service.
Cell number 21.
21.
Please, my lord.
Referring for-
Status matter that order is passed against that person.
My lord, yes, this will here, passer is asking for stay.
My lord, 1615 days delay, my lord. In trial court, appear not filed the written statement also, my lord.
He died by that time. That's the whole thing. He died by that time. Pass over this matter, I'll hear in the afternoon after the other list. Yes.
My lord, this
22,
matter is
madam.
connected,
Mine-
this matter is connected with the 5607/25.
That has been listed, but 22.1. My name may be deleted, but there is also corporation appeal filed by Rajshekhar. His name may be shown.
In 22, delete the name of Mr. Dabali. What's the name?
Rajshekhar, but it has been listed, but
That's Rajshekhar.
22.1.
In 22, Mr. Rajshekhar is directed to take notice. In 22.1, Mr. Shastri is directed to
Yes.
take notice in 22.1.
We have
Then
already
I
filed
number
Vakala.
1 of 25 is filed to condone the delay of 350 days. And how much is the delay of, it's only 71. I number 1 of the 25 to condone the delay of 350 days, condoned on condition. I number 1 of 24 to condone delay of 71 days, condoned, admit final hearing.
23. Sripad B. Shastri. Memo for.
My lord, I am
Memo is
for
with
appellant, my lord.
dispensation notice to R1 dispense
Yet to
with.
receive copy, my lord. The
Huh?
copy is not served on me, my lord.
I
Both of
served
you-
the copy anyway, I will serve again. I
No,
appeal
both of you exchanged there.
Yes, yes.
The admit form. Give him the copy, Mr. Shastri.
Kodthen. I will serve.
Yes,
Actually,
memo
sir,
is filed in dispensation of notice to R1 dispense with I number 1 of 25 to condone the delay of 130 days condoned on condition. Admit final hearing TCR.
25. K.
Say
Shansraj.
memo for R1, yes, admit final hearing.
Cell number 26.
Memo for R1 dispensed with list after service of, who is R2?
New India.
Who appears for National Insurance Company?
National.
New India Assurance. National.
Huh?
I appear, my lordship.
New India.
New India, you appear. Mr.
Yes,
Ashok and Patil is directed to take notice. I number 1 of 25 to condone the delay of 32 days condoned on condition. Admit final hearing. Yes,
Cell number
next.
27.
Memo for dispensation of notice to R1 dispensed with R2 is
National Insurance.
National Insurance Company. I see Betsur is directed to take notice. I have 1 of 25 to condone the delay of 25 days condoned. Admit final hearing TCR.
28. Nandish Patil.
A week's time default order.
Cell number 29.
Yesterday's matter, my lord, I'm requesting for stay, my lord, because the property is being auctioned on 10th, my lord.
MFA.
Please, my lord. In the execution petition, my lord, owner's appeal. Lord,
I'll
liabilities.
pass over. I'll see
Pass
in the
over,
afternoon. Yes, 29.
29.
Actually, liabilities are.
Yes, madam.
No, they have filed a review petition before the MACT, my lord, and the order
That's
has been
considered.
reviewed. Order has been reviewed.
29?
Submission is that, madam. Tribunal has dismissed the appeal, my lord, claim petition. I have submitted the prayer for seeking compensation. That is wrong, that is the office. We have to ask only the set aside the order. Only that is wrong, my lord, because the tribunal, permit your lordship, turn to page number.
Yes, I will see. Afternoon. Yes, 29. Yes, 30. List after service of notice. It is submitted that the appellant insurance company has already deposited the amount and produced the receipt. 31.
31.
List after service of notice. 32 also.
Tell me 33.
Appear for appellant, my lord. In this case, doctor's notice.
What about notice to the respondents?
Notice is not issued, my lord.
Who are the respondents?
Sriram General Insurance Company.
Sriram General Insurance.
Chivannagoda is there.
Chivannagoda is directed to take notice. What about the other respondents?
Dispensation, no, madam. R1 is necessary party, madam.
Yes, notice to R1.
Please, madam.
Yes,
Tell me
next.
33, 34.
I number 1/24. I think who appears for the respondent? Notice to the respondent. 35.
Tell me 35.
Notice.
Tell number 36.
Notice.
Tell number 37.
Notice.
38.
Notice. Not notice. Already served. I number 1
Serial number 30.
on the
489
delay
days.
of 489 days condoned on condition. Admit file hearing TCR. 39.
39.
Notice to respondent number 1 may be dispensed.
In which case?
39.
Notice
Respondent
to
number 2 is
one.
New India.
Notice to 1. New India issue. Who appears?
India Assurance.
I appear, my lordship.
Mr. M. Venkatesh is directed to take notice on behalf of the insurance company.
Please, please.
I number 1, 72 days delay, condoned on no condition. Yes, admit final hearing TCR. 40,
KV Nayak.
211 days condoned on condition.
My name may kindly be deleted, madam.
Delete the name of
Ravi
Mr. Ravi Samprati. Yes, 41.
41.
Respondent.
I number 1/25, 183 days on condition. Memo seeking dispensation to R1, dispensed with, admit final hearing TCR. Yes.
42.
Notice I appear for the response.
Notice to the
42
respondent.
days. 40
42.
48, I'm sorry.
Yes, 43. Notice to the respondent.
Tell number
44.
44, my lord. Bajaj alias General Insurance.
R1 is Bajaj.
Who appears Bajaj Alliance? Mr. Jagdish is directed to take notice on behalf of the insurance company. What about the other respondents?
Notice has to go.
Notice has to go. Notice to R1 is 45. Notice to other respondents.
Is United India.
The United India, who appears?
I appear for them.
Geeta Raj is directed to take notice on.
Manjula Tejasvi. Manjula Tejasvi.
Manjula Tejasvi is directed to take notice
51 days.
on behalf of respondent number 2.
251
I number,
days. Delay may be conducted.
if you permit me, I will do it. I number 1/25 to condone the delay of 251 days, condoned on condition. Yes, 46.
46.
You'll have
There's
to
a delay of
46
five days.
may be condoned. It may be listed along with
There
the.
are other three connected.
Yes, list along with so and so. I number 1/25 to condone the delay of 5 days, condoned, admit final hearing.
47.
TCR post along with so and so. Yes, 47.
My lord, I am for respondent.
My
My
lord.
lord, there is another connect. Stay may be granted. Some complication is there, but it may be called along with 1085/25.
10.
85/25 before the division bench. My appeal.
Before that? Why should we grant stay now and list along with that? This will let
No.
this also go. It is
Yes,
submitted
yes.
that the connected matter is pending before the division bench, that is 1085 of 2025. List this matter along with that.
Seeking stay, my lord.
Tell number 48.
Why will we grant stay when the matter has to go before the division bench?
Please, my lord.
48.
Yes,
Delay of 42 days. my lord.
yes, I number 1/25, 42 days condoned, admit final hearing TCR.
49.
Much okay.
Manjula.
Yes.
Dentist time.
What about amount deposited or not?
I'll just inquire. The concerned officer was on leave, so I couldn't get the information. With a
This is
week's time
not-
may kindly be given, your lordship. I'll
A week's time for filing the proof of deposit. Yes,
oblige.
50.
Delay of 1 day.
We will see later. Yes,
Tell
50.
number 50.
I have received the copy. I'll.
1/25 to condone the delay of 138 days, condone, admit final hearing TCR. Yes, 51.
1.
Same.
134 days, condone final hearing. 52.
52.
For the appellant, copy has been served on the
445 days, condoned on condition.
short question, it may be dismissed, case of death, my lord.
This matter, list on, Wednesday? Wednesday. Yes, 53. One of, who is the respondent?
KSRTC.
Where is Mr. Dabali? Mrs. Dabali is directed to take notice on behalf of the insurance companies. Council says of the copies, 827 days, condoned on condition, admit final hearing TCR. What about 54?
Appellant, my lord. Dispensation of R1 and R3, my lord.
R1 and R3 notice dispensed with. R2, who appears?
R4 New India.
New India, National Insurance, my lord.
R4, R2 United India.
United India.
R2 is United India and
R2 United India.
Yes, ma'am.
Huh? R2, you were for R4. R4, Mr. Ashok and Patil, R2 so and so. Yes. Then
673 days delay, madam.
delay of 673 days, condoned on condition, admit final hearing TCR.
55.
I appear for appellant.
My lord, another one petition is pending, my lord, connected matter.
List along with that, 54, list along with that. Yes, 55.
55.
I appear for appellant.
Stay matters I'll hear. Yes, afternoon. Yes, 56.
Yes.
56.
IA number 1025 to
Kindly
condone the
pass over,
delay.
my matter may be disposal.
Huh?
Matter may be disposal.
56.
56, pass over, ma'am.
Pass over 56, 57,
Manikanta.
notice, 58.
8.
I am appearing for the appellate
This
matter.
also pass over, stay matter, pass over, 59.
59, one more appeal filed by the insurance company. Yes,
List along with so and so. Who has filed?
SV Egde Mulkund.
Mr. SV Egde Mulkund is directed to take notice. IA number 1 of, notice, any other parties are there?
R1 is there, my lord.
Notice
R1
is necessary?
Please, my lord,
Notice.
please,
List along with so and so.
please.
60,
60, my lord, R1 notice may be dispensed.
R1 dispensed with, R2,
R2 is United India, my lord.
United India. Mr. Betsur is directed to take notice. IA number 1 of 25 to condone the delay of 101 days, condoned on condition. 61,
61, my lord, R1 notice may be dispensed.
dispensed with R2.
R2 is Ipcot.
Who appears? Pradeep is directed to take notice.
Please.
Delay of 221 days, condoned, admit final hearing TCR. Yes, 62,
In this case, company appeal, my lord, insurance company.
pass over, pass over, 63.
63.
Stay petition, pass over. And in this matters for admission, for 64, if any case.
64 may be pass over, ma'am. Case of death, my lord.
64 pass over, 65.
55.
Who is 65? Notice to the respondent, 66.
66.
Notice,
Cell number 67.
notice.
My lord, I am for appellant, but 67 HDFC is there, my lord.
HDFC. Mr. Lingaraj is directed to take notice on behalf of the insurance company. Only one respondent.
First respondent, my lord, first respondent insurance company. Second respondent, my lord, I will file the necessary dispensation memo, my lord.
Again, for that time, one more time it should come. This matter, and counsel for the insurance, appellant shall serve the copy on the counsel for the insurance company. List this matter after a week. Yes, 68.
Cell number 68.
Appellants, proxy counsel, at least 2 or 3 weeks time.
For what? Notice to the respondent. Yes, 69. Admit final hearing TCR.
70.
I'm applying for the appellant, my lord. Issue notice to.
Notice to the respondent.
Cell number 71.
This is for the appellant. Kindly pass on.
Pass over. Yes, 72.
72, I pray for a week's time, they have deposited.
A week's time
Cell number 73.
Proof of
For the
deposit.
appellant, my lord.
for filing the proof of deposit after a week. 73.
Issue notice to all respondent, my lord.
Yes, notice to the respondent. 74.
My lord, 74, my lord, insurance company appeal only in the question of no, this thing, driving license, my lord. After the amendment, the accident took place. Praying for stay, my lord.
No, we will do, I'll see all the stay matters in the afternoon. Yes, 7. What you do is, all the passovers and the stay matters, first call immediately, then we'll take up the 230 list. Yes, 75.
75.
Note R1, I'm filing the
One dispense with
R2 United India Insurance.
United India Insurance. SV Egde Mulkund is directed to take notice.
Cell number 7.
Admit final hearing TCR.
Cell number 76.
This is a stay petition, this also in the afternoon. 77.
77.
Notice,
Notice to all respondents. All respondents.
under notice.
Cell number
78.
78.
Payments appeal, my lords.
Notice,
Notice may be directed.
Serial number 79,
notice,
80, 79.
done.
But on submission, but serial number 16, it has to be called with along other matters. I'll furnish the.
Give
Please.
her.
Madam, serial number 15, third list on the 19.
List 4 ಇನ್ನು ಕಲ್ತಿಲ್ಲ.
Madam,
32 ಮಧ್ಯ.
Ma'am, list 3, ma'am. Ma'am, list 3, 34, ma'am.
ಪಾಸ್ವರ್ಡ್ ಆದ್ಮೇಲೆ 230 ಲಿಸ್ಟ್ 230 ಲಿಸ್ಟ್ ಆದ್ಮೇಲೆ ಇದು. ಅಲ್ಲೂ ಹೋಗಂಗಿಲ್ಲ.
ನಾನು ರೆಸ್ಪಾಂಡೆಂಟ್ ಅದರಲ್ಲಿ ಇದು ಕ್ಲೈಮೆಂಟ್ ನಮ್ದು ವಿಜಯ್ ಕುಮಾರ್ ಅವ್ರ ಇನ್ಶೂರೆನ್ಸ್ ಅವರು. ಹೌದು ಕರೆಕ್ಟ್ ನಮ್ದು 4622. ಸರ್ 4622.
ಇದು ಬೇಡ ಇರು, ಅದು ನೋಡೋಣ ಏನಾಗಿದೆ.
ಡಿಲೇ ಎಲ್ಲ ಕಂಡೋನ್ ಆಗಿದೆ ಸರ್. 42 ನೋಟಿಸ್ ಆಗಿದೆ. ಡಿಲೇ ನೋಟಿಸ್ ಹೋದ್ಮೇಲೆ ಡಿಲೇ ಸರ್ವಿಸ್ ಕಂಪ್ಲೀಟ್ ಆದ್ಮೇಲೆ
53, sir.
34 ನೋಟಿಸ್. 15 ಲಿಸ್ಟ್. ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಥರ್ಡ್ ಲಿಸ್ಟ್. 2 weeks. Dinesh 14%. 14%.
ಪ್ರೊಫೈಲ್
2 weeks. No submission. ಇದೇ ಸ್ಟೇ ಆರ್ಡರ್ ಮೊದಲು ತಗೊಂತೀನಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
serial number 55 ಬೇಕು.
ಇದು ಸ್ಟೇ ಸ್ವಲ್ಪ ಫಿಫ್ತ್ ಫಸ್ಟ್
55
ಕನೆಕ್ಟೆಡ್ ನಂಬರ್ ಹೇಳಿದ್ದಾರೆ. Whatever 65 notice.
66 notice. 21,
It's just clean the rest. Notice. 70 notice. 71 process.
R1 differences.
Notice only, see there.
Notice to respond number 1, list number 5.
Madam. Madam. List number 3. ಒಂದು 20ರಲ್ಲಿ ತಗೊಂಡಿರ್ಲಿಲ್ಲ. 69 ಅಡ್ಮಿಟಾ? ಅದೆಷ್ಟು ಬೇಕಾದ್ರಿ ಎಲ್ಲ?
ಅಲ್ಲಿ ಬಸ್ ಫೈಲ್ ಬುಕ್ ಎತ್ಕೊಂಡು ಅವಸಾನ ಇತ್ತಾ
Lords, may I mention, my lords? List number 5, serial number 11. I am for the petitioner, my lords. Council is not keeping well. He just left some problem in the family health issue. 6 for adjournment, my lords. It's for preliminary hearing.
Serial number?
List number 5, serial number 11.
Yes, this is matter on 18th of November.
Much obliged.
Call the parcel.
Passovers matters, list number 1, serial number 1. Purushottam H.
Yes.
Kumar Vasan Fakirappa.
My lord, I am for petitioner, my lord. My lord, actually that I am a coolie, my lord. Actually, I am working as a coolie.
Let's read the judgment. What did the court say? How much is awarded?
6,000 and
6,000, my lord.
6,000 per month.
per
Yes, ma'am.
month to the first petitioner and for
4
the
months,
daughter
that is
4,000 for second
1,000
petitioner,
is
my
better.
lord. A total 10,000. In the IA, it has
Come
been
to
reduced to
the-
50%, my lord. 5,000 it has happened.
After institution of the petition, the notice is ordered to be issued to the respondent. On service of the same, the respondent appeared before this court, so and so, but did not file objection even after giving sufficient opportunity.
Meanwhile,
So
my lord,
nothing is there before the trial
page
court.
number 19, meanwhile, my lord, no documents have been placed regarding that whatever income it has been placed, either assets and liabilities
Forget
like
about
that.
what she did.
Yes, my lord.
You have not appeared before the court.
Before the court, for the reason, my lord, what happened is the petitioner, she herself spoke with the respondent and they stayed together thereafter, my lord. Actually, after filed the petition, few days. Again, they departed from one another, but judgment being passed, he was not knowing because he's a coolie person, my lord. He is roaming with different places because he's working as a coolie in coffee estate, my lord. He's a labor person and he's earning very less. For the reason he was not knowing, and he's not well educated, my lord, for all the things. For the reason he has not been appeared before the court. After this, it has been filed like this, my lord. Based on that, together with that, my lord, income of the things, they have not been placed even a single document, my lord, to earn the things. However, the court been passed 10,000, my lord. First petition 6,000, second petitioner 4,000, my lord. And the petitioner is staying in the village, my lord. In the village, it not required much more that extent to lead the life with the things, my lord. And they have not been followed that the judgment of this Rajneesh versus
It will not
Neha.
apply to you.
Sorry, my lord.
It will not apply to you. Rashish versus Neha applies to
Not
wife,
been
but-
followed, my lord. Not been followed because they have not been disclosed that the income, my lord. Because being a coolie, it is very, very difficult to earn in that rural
When you
area.
are relying on a judgment of Rashish versus Neha, when according to you it applies to the wife, it also applies to you. Judgment
Please,
says,
madam.
if you do not file your statement of assets and liabilities, an adverse inference has to be drawn against you. So now whatever the wife asks, we will grant.
No, my lord. The reason is, see, being a coolie.
Please
the-
don't tell all
no.
this. What is the amount you are ready to pay? That's the only thing. All these are not legally tenable grounds. Yes.
Based on the income, my lord, see, I am living in the rural area. I am a coolie person.
Why, you will
And
tell
see,
the
it is
court,
difficult.
you
It's
will tell
ve-
the court what is the income, or I will do the, I will assess
I'm-
basing on this submissions.
I'm ready for the 3,000, my lord, both, for both the petitioners, because in.
Very good. Yes.
That it is after, even though I have not produced, the trial court has assessed that 25,000 rupees per month for the income. That therefore, my lord, that 10,000 is awarded. So based on that, even according to that, my lord, at least then 5,000, 3,000.
According to you, what is the occupation of the husband?
That according to the statement, my lord, that he is running a shop, but that I could not place the materials, that he is having a house and the site at Mysore. But as the materials are not placed, my lord, that the trial court has assessed the 10,000 rupees. That at least that 5,000 and 3,000, it's 8,000 rupees is reasonable for that.
Please come.
My lord, they have not been placed, whatever it is there, we have got resident in Mysore and all, everything, my lord.
Agreed with orders passed.
Page number 19 and 20, it is there, my lord, the
Mistake,
documents
criminal
which they have
mistakes
been
number
produced.
133 of 2023, dated 10 July 2024, whereby the court had granted 6,000 to the wife and 4,000 to the child. The husband is before this court. The criminal miscellaneous is filed seeking compensation maintenance of an amount of rupees 15,000 each to the wife and to the daughter. It's a case of the wife that the marriage was solemnized on 29/5/2019, and after the marriage they lived happily, and they're blessed with the girl child. As a petitioner, as a husband, because of the disputes between the parties, she gave a complaint to the police. And from 19/7/2022, she is residing in her parental house. According to her, husband is a businessman and is earning more than 1 lakh per month, and he is having his own house and site at Mysore, but he has failed to maintain the wife and the daughter. They require 15,000 per month. Next paragraph. The trial court has issued notice to the respondent. On service of the notice, the respondent appeared before the court, but did not file any objections, even after given sufficient opportunity. Thereafter, the court has passed the impugned order. While passing the impugned order, the court has considered the judgment of the apex court in Rashish versus Neha and observed that the court has to do the guesswork in estimating the income when the sources of income are not disclosed. In this case, the parties appears to belong to the middle class. The wife has claimed 50,000 each, and according to her, the husband is a businessman, and no material is placed in this regard. In the absence of this, it is to be held that monthly income of the husband is rupees 25,000. But taking into consideration the facts and circumstances, court has granted 6,000 and 4,000. Next part, non-counsel appearing for the husband submits that husband is a coolie and in search of work. He'll be going from one place to the other. The According to the petitioner, the wife has not filed her statement of assets and liabilities, and the court has not followed the judgment of the apex court in Rashish versus Neha. As he's not having sufficient income, it is not possible for the husband to pay the amount. When the wife says that he's a businessman and earning 1 lakh, no material is placed before the court. It is submitted that the amount of maintenance that is awarded by the court, the petitioner, with his income, he cannot pay the amount, and the maintenance amount needs to be reduced. Next part, land counsel appearing for the respondent, wife submits that when an opportunity is given to the husband, he has not utilized the same, and even before this court also, he has not placed any document to show what is his income. It is submitted that only for the purpose of avoiding payment of maintenance to the wife, the husband is coming before this court with all these kind of with these kind of statements. It is submitted that it is a duty of the husband to take care of the wife and the daughter, in which the petitioner has failed to do. It is submitted that he cannot rely on the judgment of the apex court and Rashish versus Neha when he himself has failed to comply with the same. Next, having heard the counsels on either side, there is the material on record. According to the wife, he is earning 1 lakh per month and he is a businessman. In her own petition, she has stated that he is not doing any work, and because of that, and he continuously is consuming alcohol. Because of that, the disputes have started between the parties. When the wife alleges that 1 lakh is the income, she has to place the material before the court, but no such material is placed by the wife before the court. According to the husband, he's a daily wage laborer. Considering all these aspects, balancing the interest of the wife, balancing the interest of all the parties, this court is passing the following order. The order dated so and so, dated so and so, by so and so, is modified. The amount of maintenance that is granted to the wife is reduced from 6,000 to 4,000, and the amount of maintenance that is awarded to the daughter is reduced from 4,000 to 2,000. Accordingly, the RPFC is disposed of.
List number
Yes.
2, scale number 10. 40, Renuka HR.
Lord, I don't have the records, my lord, except the appeal memorandum. The dismissal is, its claim petition is rejected, dismissed, my lord. So matter.
It appears that the police records are speaking something else. Show her the copy, which is, this is 11, 10.
If the TCR is here, my lord.
This is matter on 26, by the time the
My lord.
TCR shall be called.
TCR is there.
It's there, yes, 26.
My lord, I may be permitted to see, my lord. I'll see now itself. The TCR, I'll just have a.
Yes.
Serial
26.
number 21. Number 2, serial number 21.
Appear for respondent.
Table is at 18 millet, case of injury millet. Judgment page 18. I was sustained a fracture of both bones of leg millet. He was in the hospital for 86 days.
How
millet.
many days?
86 days millet.
Oh, that
Two
is-
occasions.
I have gone through it, 86 days.
So 86,000. Where is the table? You said page number?
18, my lord,
18.
para 29.
Page number 18.
In page 18 millet.
Paragraph number?
29, my lord.
Hmm. Hmm. So, incidental expenses, 86,000, medical expenses, loss of income in the later period, 93,000 is given.
Correct, my lord.
Then what about this loss of future income?
Loss.
Future income is, disability is,
41% to right lower limb, my lord.
Hmm.
Whole body 21%. One third may be taken and disposed.
Court has taken how much?
10%, my lord.
10% has taken.
Injury is grievous, my lord, is a
1 divided by-
non-union of fracture, my lord.
You said how much can be taken?
My lord, one third, my lord, comes to around
14.
14.
15% is justifiable, my lord. 15% is justifiable because he is working as a security guard, disability.
Which year is that?
22, man.
What is the income?
15,500.
Same is considered.
15,500 into 12 into, what's the multiplier?
17.
17, my lord.
Into
17.
14 by 100. Any future operation, look at the.
Yes, my lord. Doctor says the implants is switched. Amenities is the lower side.
1 minute.
Like, please.
Comes to 4,42,000. According to the doctor, how much it costs? Future operation.
He has not stated any amount, my lord.
Cost is not stated, but
Will
implants
grant,
is there.
will grant 30,000.
Please.
Loss of amenities, how much is granted?
30,000, my lord. He was in the hospital for night 6 higher side.
But pain and suffering 75,000 is granted, my lord. Maybe
So
compensate.
we'll maintain that 30,000.
Please, ma'am.
Legal expenses 10,000. So it's coming to 7,72,580 against 5,74,100. Discount. Agreed with award passed in MEC number 2868 of 2022, dated 25th November 2024. The claimant is before this court seeking enhancement of the compensation. The tribunal has awarded the compensation as per the table given below at paragraph number 29. When counsel appearing for the claimant submits that when the claimant was in hospital for 86 days under the incidental expenses, only an amount of rupees 54,000 is awarded. As per the doctor's evidence, there is a future operation. No amount is awarded under the said head. It is submitted as per the doctor's evidence, 41% to the limb and 21% to the whole body is a disability, but the court has taken 10%. Then it is submitted that on all counts, the compensation needs to be enhanced. Next, and counsel appearing for the insurance company submits that the court has rightly considered and granted compensation. No interference is called for. Next, having heard so and so. Under the head of pain and suffering, medical expenses, loss of income during the later period, and loss of amenities, court had granted a reasonable compensation. No interference is called for. Coming to the loss of future income, the doctor had reported that 41% is to the limb, 1/3 of it comes to 14%, as this court is inclined to take 14% as a disability. 15,500 into 12 into 17 into 14 by 100 is 4,42,680. According to the doctor, the future operation is required. In that regard, this court is granting 30,000. Altogether, the claimant is entitled for an amount, in the light of the law laid down in Mekala 10,000. Altogether, the claimant is entitled for an amount of rupees 7,72,580. Accordingly, the appeal is partly allowed, enhancing the compensation from 5,74,100 to 7,72,580. Enhanced amount shall carry 6% interest. Yes.
Much obliged.
22, Devi Nayak.
Yes.
Case of death, my lord.
my lord, only one ground, my lord.
Case of death.
Case of
Where
death.
is the table?
Table, my lord, page number 23 of the judgment.
Hmm.
My lord, all aids are given, my lord. Only one point, my lord. But future prospects, my lord, 50% to be added, my lord.
What is he doing?
He was doing, my lord, customer solution agent at Pile Industry Private Company.
Then why 50 should be given?
Well,
Is it a permanent employment?
My lord, he was undoubtedly he was working as a company, my lord. It was stable employment, permanent job, my lord.
That is not stable employment. They are referring to a permanent, a government job, not a private job.
Oh, produce the my lord, exhibit 10 appointment letter.
Doesn't matter. So that's the only ground.
Only one ground.
Please come. The present appeal is filed. Agreed with the award passed in MSC number 999 of 2023 dated 3rd February 2025. The claimant is before this court. The tribunal has granted the compensation as per the table given below at paragraph number, at internal page number 32. Then counsel appearing for the claimant submits that the court had granted 40% future prospects instead of 50%. It is submitted that he's working in a
my lord,
He's working in a private
customer
company.
solution agent at a Pile.
He's working in a private company.
Yes.
It is a stable employment. So it has to be, considering it as a permanent employment, 50% has to be added. Land counsel, next per land counsel appearing for the insurance company submits that court has rightly considered it is not a government employment. As such, it is entitled for 40% future prospects and no enhancement is called for. Next, having heard so and so. This court has perused the award that is passed and the court had rightly considered and rightly taken 40% future prospects. The petitioner is not entitled for 50% for future prospects in the light of the second law. Accordingly, the appeal of the claimant is dismissed.
Bill number 23, Venkatagowda K.
Yes.
For appellant. Ravish Benny.
Claimant appeal, my lord. Only on quantum, my lord. Relevant para, table, para 25, my lord.
20?
25, my lord. Para 25 of the judgment.
Yes, what are the injuries?
My lord, injuries, para 17, my lord, is sustained fracture of left femur and severe injury to the left hip. There are 2 injuries and he was inpatient 18 days.
Yes, another 10,000 towards pain and suffering. Medical bills as it is.
And income has taken, my lord, 12,000.
Look at the table. That's how we will go.
Pain and suffering.
The loss of, we'll skip loss of future income. Future medical expenses according to the doctor, how much?
12% doctor has stated, my lord.
Future medical expenses.
Doctor has not stated about the income, only require the operation, that's all.
Then we'll grant 30,000 in that. And then how many days he was in hospital?
18 days, my lord.
18.
18 days.
We'll grant 18,000.
And the loss of income, laid up.
Yes.
Tribunal has not awarded, my lord.
Of income. Which year is the accident?
2019, my lord.
It should be?
14,000, my lord. Tribunal has considered 12,000.
14,000 or 14,500?
14,000, my lord.
Now coming to the future earning capacity.
The tribunal has considered 12%.
12% disability.
Disability, my lord.
According to the doctor, what is the disability?
26%.
20?
26% to the whole body.
Limb?
Limb disability has not stated. Therefore, tribunal has taken 12% loss of earning capacity.
So what to do?
I leave it to
Listen
you.
until you tell the, how much it is granted? 12%.
12%. I leave it to you. Because trial court, the trial court finding is because without telling the limb disability, directly they have taken the whole.
We will let it like that. Loss of future earning capacity. How much it is? 86,000.
86. Because it was aged about multiple age 5, my lord. It was a
Court has taken how much? 12%.
12%.
We'll take another 2%.
Doctor assessed 26% disability for physical impairment, my lord. For whole body, it comes to 8.66. 8.66.
No. He said it is for a whole body.
Okay. This much.
We'll take another 2%. 14,000 into 12 into multiplier 5
5 malad.
into 14 by 100. It comes to 1,17,600. Loss of amenities,
Only tribunal has awarded only 10,000 malad.
30,000 will award.
Loss of income due to the later period.
It also have granted 56,000. It's coming to 3,58,144 against
3,000 malad.
2,944. The doctor said, what is the disability, you said?
26% malad.
Tribunal has taken 12%.
12% malad.
Please come. Agreed with award passed in MSc number 320 of 2021, dated 22nd November 2024. The claimant is before this court. The tribunal has granted the compensation as per the table given below at paragraph number 25. It is submitted that when the claimant had sustained two grievous injuries under the head of pain and suffering, only 40,000 is awarded. Further, towards the future medical expenses, the court has awarded 10,000. The claimant was in hospital for 18 days, but 10,000 is awarded by the tribunal. Towards loss of, according to the doctor, the disability is 26% to the whole body. The court had taken 12% without any basis, and under the head of loss of amenities, only 10,000 is granted. It is submitted that on all the counts, the compensation needs to be enhanced. Next, when counsel appearing for the insurance company submits that the tribunal had rightly considered and granted the compensation. No enhancement is called for. Next, having heard the counsel so and so. Considering the fact that he has sustained two grievous injuries and the head of pain and suffering, this court is granting 50,000 medical expenses. No interference is called for. For the future medical expenses, this court is granting 30,000. Incidental expenses, as he was there in the hospital for 18 days, this court is granting 18,000. Coming to the loss of income during the later period, 14,000 into 4, 56,000. Then the loss of future earning, the doctor, without assessing the limb disability, has stated that the whole body disability is 26%. Court has taken 12%, and this court is inclined to take 14%. 14,000 into 12 into 5 into 14 by 100 is 1,17,600. Loss of amenities 30,000. In the light of the law later on in Mekala 10,000. Altogether, the claimant is entitled for 3,58,144. Accordingly, the appeal of the insurance claimant is partly allowed, enhancing the compensation from 2,02,944 to 3,58,144. Enhanced amount shall carry 6%. 125 days delay interest not entitled. Yes, next.
List number 2, number 3, serial number 21.
Alert. Sorry for the interruption.
Yes.
Serial number 22, I was held up in another court. List number 2, my lord. Kindly show my name, my lord.
Yes, I said, I've recorded your contentions also. Yes. Connected appeal, my lord. I am after the appellant claimant's appeal, my lord.
Connected appeal is there, my lord. 21.1 I am.
Correct. Now they have sought for stay.
I am not aware of the facts. I am not aware, my lord. I'll take instruction next week, my lord.
My lord, it's pay and recovery. They've already been paid. It's an appeal for enhancement. Execution initiated against the LRs. I'm here for stay. Kindly.
Yes. The appeal is filed by the owner of the vehicle with a delay of how many days? 1,615 days. Learned counsel appearing for the petitioner, for the appellant, submits that. So the owner or the driver of the vehicle?
The alleged owner, I was the erstwhile owner. It has been transferred to.
No, you said that in the last order I have said arrayed as driver of the vehicle.
Lord, because in the cost title of the trial court, they're wrongly mentioned as driver cum owner.
It is stated that it is arrayed that the father of the appellants is arrayed as a driver cum owner of the vehicle. The judgment was passed on 1/12/2018 and the father of the appellants died on 13/1/2025 and the award is passed against a dead person. It is submitted that now the insurance company has filed the execution considering the fact that this is a judgment which is passed against a dead person, which is on the face of it is a nullity. They shall be stay of all further proceedings pursuant to so and so.
My lord, one submission. In judgment not mentioning dead, my lord.
If they know he died, why would they pass a judgment against him? And now your interest is protected. You have the money. It's the insurance company's headache. Yes.
Lord,
What is the respondent?
Lord, one thing, Lord, the father of the appellants are not arraigned as driver cum owner. It is the respondent number 1 who is arraigned. I have just been arraigned as erstwhile driver, erstwhile owner. I was the previous owner of the vehicle.
Give that. Give the order sheet. So he is arraigned as erstwhile owner of the vehicle.
It doesn't say anywhere, my lord. That's my grievance. In page 13 may be seen. The cost
How
title.
you are arraigned? Something you must have been arraigned in the judgment.
They say owner.
Yes. You please correct this. Now also he is arraigned as owner of the vehicle.
And my lord's date of death said 2025. It's 2015, man.
That's what I said. 2015. 13/1/2015. Yes.
Till number 28. Till number 28.
Owner's appeal, my lord. The date of accident is 25/5/2016. My lord, the
Date of accident is?
25/5/2016, my lord. My lord, the LRs of the claim of the deceased, my lord, filed a claim before the MACT, which came to be allowed, my lord. And my lord, the liability was fixed on the insurance company. My
When
lord.
was that award of fixing the liability on the insurance company?
My lord,
May I submit today, just 2 hours back, my lord, what the copy, certified copy of the judgment which he has produced, in that I have been held liable. But
You
my
have to
learned
question
friend
the
says
order in the
you could have-
review.
my lord, it was disposed of on 30th August 2019, my lord. Subsequent to which, my lord, the insurance company filed a review petition before the same court.
You were not served with the notice.
My lord, we have served, we have been
Are you
represented.
not supposed to question that order in the review? That's what I'm
My
asking.
lord, I had in fact filed earlier questioning the review, but this court, my lord, held that I have to question the modified order.
No, both the orders you have to question. The original, if you're agreed with the original and the.
No, my lord, I am not agreed by the original.
Order only you have to question.
Modified order is questioned here. Modified order is questioned here. What happened in the review was, my lord, now, my lord, the liability has been shifted to me, the owner. My lord, my humble submission is, my lord, the review, my lord, there is no error apparent. Your lordship could kindly see, my lord, the order, my lord, at the liability and the finding on the liability
Your lordship,
at page 26, my lord.
1 minute.
I want this honorable court, if court feels fit, to grant, because he says
Sale
that some
proclamation
attachment
is
has
there
come.
on
I
Monday.
will verify with the company, and that I don't know, because now the judgment which my learned friends impugned, in that there is a liability upon the insurance company.
I'll just
Modified
show two
judgment he
pages.
has to
Where is the judgment?
2 pages, my lord. I'll just show. We applied for the modified judgment and award. This is what is given, and liability in the award is as against me, but in the judgment is as against him.
Judgment and award are quite different. That's what I also pointed out.
To have a clarification on that, you have to seek the clarification from the court.
My lord, if your lordship sees page 33, my lord, the award, which is put for execution.
What the decree says?
My lord, the decree says that the insurance
So
company
what is
liable.
executable?
My lord, but my lord, in the execution now, my lord, sale
What I'm
proclamation is
saying, in
issued.
the execution,
Please.
they will execute the decree. If it is against them, that is for them to clarify that.
The decree which my learned friend has put, there is no award against me. But in the judgment, judgment says
What
I
he's
will.
saying is award is against you.
No.
Award is as against me.
No, where is the decree? Let's see.
My lord, your lordship may kindly see page 27, my lord. Page 27, the last paragraph.
No, this is not, this is the judgment.
This is the judgment.
Mm.
My lord, page 27, my lord.
There is no decree.
There is a decree. I have attached
Please show the decree.
page 33, my lord.
What it says.
My lord, second paragraph. The first respondent is directed to deposit the compensation
That is you.
within two. That is the owner, my lord.
One sentence above, the award says petition against third and is hereby dismissed.
For second and third.
The driver and the insurer.
No, second
I
is.
don't know, but judgment says otherwise. I don't know how.
My lord,
this is
second is the driver, my lord. Third is the insurance.
The first respondent is directed to deposit the compensation. First respondent is Indrani,
That is
owner
the
and
owner.
tractor of the trailer.
I don't know what ground they buy, but the judgment says this.
Oh, look at that.
Yeah, yes, decree. Your
Let him, in the meantime,
please
get the judgment, this amended, and file
I will
a
also
amended
get
copy.
instructions. I will also get it. Now just.
It is submitted that the present appeal is filed with a delay of 855 days. It is submitted that initially the judgment and decree was passed on 30th August 2019, where the liability is set on the insurance company. Thereafter, insurance company has preferred a review. In the review, the insurance company is exonerated and the liability is fixed on the owner of the vehicle. As such, the owner of the vehicle is before this court. It is submitted that there is no error apparent on the face of the record, that the court has to review the earlier award passed on 30th August 2019. Next paragraph. Land counsel appearing for the insurance company submits that if, as per the award, the liability is on the insurance company. In response to that, land counsel appearing for the claimant submits, the owner of the vehicle submits that the decree shows that the first respondent, that is the owner of the vehicle, shall deposit the compensation within 2 months from the date of the award. The petitioner, the appellant or the insurance company should have sought for the amendment of this in the light of this confusion. However, considering the fact that already the execution is filed, there shall be stay of all further proceedings. 50% deposit.
But 15%. She has some difficulty, my lord. 15%.
It's a usual order.
Not for the insurance company.
What insurance company? For a owner of the vehicle also it's the same.
Some concessions.
There shall be 25% on deposit of 25% of the amount within 4 weeks. Then within 4 weeks from today, the amended copy of the judgment shall be filed.
Please oblige.
Notice to the, Mr.
My initial has to be corrected. My initial has to be.
Where is K.R. Lingaraj?
That is.
Mr.
H.S.
Lingaraj. The name, in the cause list, it is printed as K.R. Lingaraj. It shall be corrected as H.S. Lingaraj. Notice to the other respondents.
Lord, may I request the order be uploaded, my lord, because Monday is the execution.
Yes, next.
Cell number 29.
Yes.
H. Ramachandra.
Second round of litigation matter. Earlier, this honorable court had remanded the matter. For
Let's see what is the question? Where is that?
Their objection is I have to restrict one to set aside the
Let us
award.
see where is it.
only objection, only it is there in your file, your lordship. Objection raised by the office.
Not passed in MVC number, dated passed by the so and so, and to pass out towards dependency and loss of earning. Prayer won't be like this. What are all
No,
this?
no, because earlier, the court, tribunal has ignored the remand order.
Please understand.
Yes.
That would be your grounds, sir. Prayer is only one. You will not ask all your, whatever your grounds are there, that won't be there in the prayer.
No, but only thing, Miller, only by set aside the judgment and award, and no prayer for my awarding compensation will affect my rights.
Counsel, what did you ask in the prayer? For set aside the judgment and award passed in so and
that
so.
I have to
So and so. Then towards dependency and loss of earning, though the claimant and the deceased, what is all this?
Because my prayer is required, but even otherwise also, there must be one prayer, at least to award the compensation suitable. That is to be allowed. No, you have to restrict only to the first only. Set aside.
They're absolutely correct.
No, what about my prayer for awarding the compensation?
I think something is like you're not understanding. Will anybody ask prayer? Will anybody ask the ground? Will raise the grounds in the prayer?
Grounds are there. For a moment, your lordship, earlier judgment passed, remanded by the decision of court. Really, take a note, 83.
It's not about interim prayer. The prayer is you can't ask all that in the prayer.
Or at least one prayer per grant of
Office objections are sustained.
For a moment, your lordship, turn to the earlier, the court has ignored the remand order. That's what I'm submitting. For a remand order, for a moment, 83 page number, Miller. Page number 83. For a moment, this honorable court has allowed both the appeals filed by the insurance company and also the appellate, the counter appeal filed by me.
First of all, you remove all those, what you want to incorporate, you incorporate, then we will see.
That your lordship.
I will not say, you do. If then office raises any objection, then you come. Can anybody file a petition with all those kind of prayers?
No, even there must be
Office objections are sustained.
No, yes. Even otherwise there must be prayer for awarding the compensation.
No, yes.
Say number 55.
Yes.
KSRTC appeal, corporation appeal.
Yes.
She was a passenger of the first, as per the contention of she was a passenger.
The case of death or injury?
Injury.
How much is the compensation awarded?
Compensation award. 4
Sir,
lakhs.
on what ground?
4 lakhs.
On what ground?
Because she was a passenger, she himself fallen in the bus. She himself fallen in the bus. There is no negligence of the driver of the case. It is simply they are. That is the.
In the bus, she fell down.
Yes.
On her own negligence, she fell down.
Yes.
And there is no liability on the.
No, liability driver. Is there, but negligence, contributory negligence attracted. Because of this, she
deposit 75% of the compensation.
No, she is taking contention different in the fact.
On such deposit, the respondents are
50%
liberty to withdraw.
50%, my lordship.
No. This is straight away. I should hear this.
No, my lordship, she is taking contention different. She's.
Shall I hear the appeal itself?
50%.
Entire compensation to be deposited. When counsel appearing for the appellant submits that she is traveling in the bus as a passenger. She fell down and sustained injuries. According to the appellant, because of her mistake, she fell down and sustained injuries, and there is no responsibility of there is a contributory negligence on the part of the claimant. The insurance company the RTC shall deposit the entire amount, and the claimant is at liberty to withdraw 75%.
Malaysia, 50%. Malaysia.
If you insist, I will hear the appeal. On the merits and now itself, I'll.
75%.
Yes. Next.
Notice to the, say number 50.
Notice the respondent.
56. Gurudev Prasad KT, B Pradeep.
56.
56. 118 days delay in filing the it's a case of injury.
Where is he? Yes.
Internal page 10, there is a table.
Yes. What are the injuries?
Injuries, fracture of tibia and fibula and fourth and fifth finger fracture of left hand.
50,000.
Please.
Then medical bills.
Medical bills 200 rupees only.
Yes. Loss of income during laid up period, how many
Laid
days?
up 2 months, my lord. 16,000 income as considered.
No, no. How many days he was in hospital?
8 days, my lord.
Will grant 3 months. Which year is this?
23 my lord. 2023, 6/8/2023, 16,000 as I already considered by the MSC.
16,000 into 3. $48,000. You said how many days he was in hospital?
8 days.
How much is granted?
20,000 my lord. Attendance.
Incidental
transport.
expenses. Hmm. Hmm. Then?
Loss of
Disability?
amenities 20,000 my lord.
No, let's go to the disability, loss of future.
Disability my lord, 12% as considered by the.
What is the evidence of the doctor?
The evidence of the doctor is that my lord, para 17.
No, is it okay? Yesterday also matter morning he mentioned again to take it up. Shall we go ahead with this or again he'll come and
Gurudev Prasad sir.
Morning, yesterday that matter, morning he came and mentioned that he will argue on this after amendment, what is the consequences of not having a driving license. Yes, Mr. Loss of future earning.
Yes.
What is according to the doctor, what is the disability?
PW3 doctor Ramchandra. Para 17.
32% to the
limb
and
how much is taken by the court?
12%.
Rightly taken. Income also rightly taken. So loss of future earning.
4,14,720.
4,14,720. Then amenities, how much you granted?
20,000.
Okay.
That will grant another 10,000.
Amenities 20.
Disability of 10%, 30% is 30,000 is fine. Then loss of pain and suffering, loss of income. Any future operation?
Future operation, the implants are there. And
They themselves have, what is the medical bills of 200 rupees?
under operation removal of implants.
So operation without any amount, future operation with amount. Pain and suffering 50,000 granted.
Yes. Laid up period.
That also granted 48,000. Incidental expenses should have been reduced. It's coming to 5,72,920 against 5,06,920. Please come. Agreed with award fasting. MVC number 5558 of 2023 dated 30th January 2025. The claimant is before this court seeking enhancement of the compensation. The tribunal has awarded the compensation as per the table given below at page 22, paragraph 22. It is submitted that when he has sustained 3 injuries, 2 grievous injuries under the head of pain and suffering, the court has not granted a reasonable compensation. When it comes to the loss of earning during the later period, only 2 months was considered by the court. It is submitted that the amenities were granted only 20,000 and no amount is granted for the future operation. It is submitted that on all these counts, the compensation needs to be enhanced. When counsel appearing for the respondent insurance company submits that he has medical expenses itself for 200. Question of future operation will not arise. Further, it is submitted that on all the counts, the reasonable compensation is awarded. Next, having heard so and so, considering the injuries under the head of pain and suffering, this court is granting 50,000. Medical bills, no interference is called for. Coming to the loss of earning during the later period, 16,000 into 3, 48,000. Incidental expenses rightly granted. Loss of future earning also quoted reasonably granted and no enhancement is called for. Under the head of loss of amenities, this court is granting 30,000. In the light of this one, so legal expenses 10,000. Altogether, the claimant is entitled for 5,02,920. Accordingly, appeal is partly allowed and answer the compensation from 5,06,920 to 5,72,920. Yes. 118 days delay not entitled for. Yes, next. No, it is, no, it has to be condoned.
Yes, ma'am.
I number 1025 to condone the delay of 118 days. Yes, next.
Cell number 58.
118.
118.
Yes.
I am for the appellate.
Which one is that?
58.
58.
58.
Yes.
3,95,000 is granted. 3,55,200 is granted.
On what ground you are before the court?
I am before the court as the question of quantum and negligence on quantum.
It is submitted
I
that
deposit 6
the
lakhs.
tribunal has granted the compensation on the higher side. Hence, the insurance companies before this court considering the submission, they shall be stay of all further proceedings. 50%, 4 weeks, entitled to withdraw. Yes, next.
Cell number
Before the MACT, before MACT.
Wherever you want to deposit, Yes.
Appearing for appellant, my lord.
notice to
Case of
respondent.
death, sir.
In all the stay matters, notice to the respondent.
Cell number
Case of
62.
death.
Which case,
Sir, is
which one is
62.
this?
62.
62.
Case of death, appeal challenged by insurance company on quantum ground, my lord.
On quantum.
Quantum.
How much is awarded?
13,77,000.
According to you, what is the amount?
6,50,000, my lord. That is aged about 70 years. And tribunal is considered 60 years. And 1/3 is
On what you are saying, on what basis
based
you are
on
saying?
Aadhaar card.
Not Aadhaar card. Postmortem certificate will be there. What is his age?
60 years in.
And then that is what is relevant.
And climate says wife and major son. That is 1/3 is there.
Even if only wife, if I have taken, I am taking 1/3 only. No grounds then.
No, my lord. Actually, as per the Aadhaar card,
You can't, how can you take Aadhaar card? You have to take the postmortem certificate for determination of age.
that is 60
Then court has rightly considered 60. That is one.
in Polish documents, 61 is there. There may
What
be
is the difference between 60 and 61?
10% future prospect is considered. That is maybe reduced.
And so how much is the amount?
13,77,000.
13 lakhs. It is submitted that the court, with regard, the age was taken at, when it is 70, the age is taken at 60. And the court has granted the compensation, which is on the higher side. There shall be stay of all further proceedings on the condition that the appellant shall deposit 9 lakhs and 9 lakhs with a period of 4 weeks. On such deposit, the claimants are at liberty to withdraw. Notice to the respondent.
Cell number 63.
Yes. Owner of the vehicle.
Owner of the vehicle, my lord. My lord, 50% had been fixed against the owner, my lord. My claim is, my lord, when the RC is not transferred to owner, RC is in the past owner.
But the vehicle is with you.
My lord, vehicle involved in identical circumstances. Recently, Supreme Court held that even I withdraw the vehicle, this is the judgment, my lord. Even I withdraw when similar circumstances.
Not required. Yes. Not required. Yes.
My lord, Supreme Court held that even withdraw the vehicle, then past owner is liable to pay the compensation. My lord, in this case, what happened, my lord? I purchased the vehicle. While handovering the vehicle, insurance has been made for transfer purpose. Even that insurance has been made fake insurance by the past owner. My lord, even accident has been taken in a highway. My lord, I am traveling in 9:30 in a highway. Divider is there. All of it.
All that will not go.
My lord,
Whatever is your 50% liability, in that 50% you have to
my lord,
pay.
50. My lord, when Supreme Court held that, my lord, I am not liable to pay.
That
My
I'm
lord,
not hearing.
my lord, I am because, my lord, I am totally financially facing difficulty, my lord. That's why, my lord, I am not in a position to even pay the 50%.
We'll hear it on Thursday. Yes, this is
My
part
lord.
on Thursday.
My lord, in the meanwhile, my lord, my lord,
Thursday.
kindly issue emergent notice, my lord. Delay,
To the emergent notice to the respondent. This is part on Thursday.
my lord, after 15 days, my lord, if this after 15 days this court list by lord, what happened, my lord, original owner also come.
If you want, I can list it after 15 days without stay. If you want stay, I will list it on Thursday.
No, my lord, give my lord, after 1 month time, my lord, record may be called. Once of all, my lord, matters should be disposed of, my
No
lord.
stay.
No, stay, no problem.
This matter.
Call for record.
Notice, emergent notice to the respondent. List the matter in the month of December. December 2nd, the registry is directed to call for the TCR. Yes, next.
Forthwith, my lord, record.
Yes.
Much obliged, ma'am.
Which is? What is the number?
Appearing for the respond number 2 in this case.
It's a case.
Madam, we received only the notice. Kindly permit the appellants to serve the petition along with the document.
Liability against you, sir. Don't worry. Owner. No liability against you.
Case of death, my.
Yes, seen this?
Millennium illa, formal party.
Here, deceased is a 23-year-old boy. So
No, yes, seen that?
Yes, ma'am.
So what was the income taken?
15,000 as considered, not instead of 15,500. 15,000 as considered.
15,500.
Fine.
Future prospects,
40% added.
would come to how much?
I mentioned in the synopsis.
3,040.
It's not mentioned.
Mentioned.
No,
Left,
no.
right side portion.
There's 40%, just you said 40%.
15,500, 40%, 50% deduction into 12 into 8.
No. 15,000 into 40, what is the amount? That's what I want. 6,000.
6,200. 6,200. 15,500.
500.
6,200.
200.
6,200. Milad, 21,700.
21,000?
700.
700 into.
50% deduction.
Oh, 50%. How much is
Bachelor
it?
death. 10,850 into 12 into 18.
12 into 18.
23 lakhs, 43,600.
Please come. Agreed with the order award passed in MBC number 1729 of 2022 dated 17 January 2024. The claimants saw before this court seeking enhancement of the compensation. The tribunal has awarded the compensation as per the table given below. Where is the table? No table.
No table.
Has granted compensation of
Synopsis.
24 lakhs 38,000.
38,000.
Then counsel appearing for the appellant submits that this accident had taken place in the year 2022, but the court had taken 15% as 15,000 as income and granted the compensation. It is submitted that even at the conventional heads also, the amount that is awarded by the tribunal is not just and reasonable. Civil and counsel for the appellant, the respondent insurance company submits that the court has granted a reasonable compensation. Next, for having heard so and so. There is no dispute of the fact that this accident had taken place in the year 2022. Hence, income is taken as 15,500 plus 40% future prospects would come to 6,200. That is 21,700. As he is a bachelor, 50% has to be deducted towards his personal expenses. Then his contribution to the family would be 10,850 into 12 into 18. Into 18 is 23 lakhs 43,600. How many are the? Three into the three claimants, 3 into 44, 1,32,000, 36,000 towards the funeral expenses. Medical expenses as awarded by the court, 9,891. In the light of the law laid down in so and so litigation expenses, 10,000. Altogether, the claimants are entitled for 25 lakhs 31,491. Accordingly, the appeal is partly allowed, enhancing the compensation from 24 lakhs 38,000 to 25 lakhs 31,491.
Enhanced compensation may be.
It will carry
Fair amount may be
6%
released.
interest. Huh?
The meager amount.
As per the terms in the award.
In the award, actually, unfortunately, the court has deposited 20 lakhs in the name of the first petitioner. For that, I had to file an application to release that amount. So they may.
But whatever it is, you take care there. Yes, next.
Cell number 71.
71, appearing for the second respondent.
Yes, where is he?
Jagdish HP.
This case, my lord, there is no scope for enhancement, my lord. Connected matter.
Yes, list this matter.
17.1, my lord, non-compliance of observation arising of same accident injury case.
We'll have it on Thursday.
Please.
And by Thursday, the office objection shall be complied with. Mr. Pradeep is directed to take notice on behalf of the insurance company. Yes.
Cell number 74.
The appeal of the insurance company on the question of liability, my lord.
On
The-
what ground?
My lord, the person who was riding this motorcycle held no driving license. My lord.
Before amendment or after?
After the amendment.
It is submitted that the insurance company is on the question of liability as the driver of the offending vehicle is not having a valid driving license. It is submitted that the accident had taken place after the amendment, considering the same. 50%, 4 weeks. Yes, stay, notice.
76. 76, Mahesh Kiran Shetty.
For the appellate. I'm sorry, morning I was held up in the other court. My lord, this is a matter wherein the other day this matter had come up. That day, my lord, I could not go through the file. The reason for fastening the liability on the owner is, my lord, that he did not possess the valid driving license. In fact, my lord, it's
When
a
was the
road.
accident taking place?
My lord,
What is the date of accident?
my lord, the date of accident relates back to, my lord, 6/1/2018, and it is a road roller. And we had
In
LM.
that case, if he's not having a driving license, then the pay.
My lord, he had the driving license to drive LMV. My lord, the vehicle involved is a road roller. My lord, it is covered because, my lord, the Honorable Supreme Court said that, my lord, that road roller is within 7,500 unladen weight. So on that basis, my lord, and that apart, it is a peculiar case wherein earlier I was placed ex parte. After filing of the execution, I approached this honorable court. This honorable court granted me stay subject to deposit of 50%. I deposited that amount before this honorable court. Parallelly, my lord, an application seeking for setting aside the ex parte was also filed. The matter was reheard. The same compensation is also now awarded, and liability is fastened on me with the direction to pay and recover.
50%.
50% is already before this honorable court, deposited by me.
It is submitted that already 50% of the amount is deposited. The appellant is the owner of the vehicle and already 50% amount is deposited. This is serial number?
76, madam.
Deposited. Hence there shall be stay of all further proceeding.
Please, madam. Oblige.
For notice the respondent. Yes.
List number 4 for being spoken to serial number 1, Girish Baldare. Bajaj.
Yes, main petition itself is
So
disposed
that
of. my
might
lord.
be, but in the earlier order, court has passed
Yes, my lord.
so that I have to correct. This writ petition is disposed of on 25th September 2025, wherein this court has observed that the judge has failed to follow the judgment of the apex court in Rashish versus Neha, and the matter was remanded back to the court. We need to call this list now. We should have called 230 list. These are not passovers, no? No. This list is at 230, no? After this call, that list, 230 list. What did you write? Remanded the matter back to the family court for fresh consideration. After that, it brought to the notice of the court that in fact, a detailed order was passed by the court, but only the docket proceedings were placed before the court. Hence, the order dated so and so is recalled. A memo is filed stating that order dated so and so is recalled. That is one that's completed. A memo is filed that the main MC itself is dismissed by order dated 5/11/2025 and nothing survives for consideration in this petition. Accordingly, dismissed as instructed. This call the
List number 5, 230 matter, list number 5. For dismissal serial number 1, Narendra S.
The respondent bank, my lord.
I think the affidavit to close the entire loan account, my lord, within 3 months, my lord, duly serving the other side also, my lord. Outstanding is 39 lakhs, my lord, as.
Take that. Have you received it?
Yes, my lord. The outstanding balance is as on 30th October 2025 is 38,43,601, my lord, and 49.
And last date, my lord, bank has approved.
Ready and willing to close on the entire loan amount in 39 lakhs as on this day, based on the calculation that I've made with and ready to pay the outstanding amount within 3 months from today. and after closure of the loan account, the respondent bank may be directed to issue loan clearance certificate along with return of the original documents pertaining to the mortgage property. What are your instructions?
Within 2 months, they can clear the whole loan.
In your 3 months is fine.
Last year, they have taken the interim order and
Uh-huh.
till then they were enjoying it.
What is that?
Last year, they have taken the interim order. Until then, they were not.
No, anyhow, at least now it is heard.
Yes, ma'am.
Now it is heard and some order is going to be passed. Yes. Whatever is, what about this outstanding 39 lakhs is correct?
My lord, as on 30th October, it is 38 lakhs 43,601.
No. Then what we'll do is,
Please, ma'am.
30 is saying about 39 lakhs is the outstanding.
As per the bank instruction only, I'm prepared the affidavit, my lord.
Hmm?
As per the bank instruction only, last time when my lords have recorded that approximately 39 lakhs.
What we do is,
Please, my lord.
30. So it comes to around 13 lakhs.
Please, my lord.
3 installments. So
Please.
what I'll say is on the last installment, because they have to calculate what any incidental or miscellaneous expenses, they will inform you that shall be added in the last installment and shall be paid. So within 3 months means today is what?
Today is 7th of November, my lord.
7th of November. That is December, January, February 7th.
Yes, ma'am.
Please come. The repetition is filed. Questioning the e-auction notice dated 26/2/2025 as illegal and opposed to law. When this matter came up before a coordinate bench of this court on 14/3/2024, stay was granted on the condition that the petitioner shall deposit 10% of the amount with outstanding amount within 4 weeks from the date of order. Remaining 10% shall be paid within 4 weeks thereafter. If any of the amounts are not paid, the stay granted by the court stands vacated. Today, an affidavit of undertaking is filed before this court. It is stated that as per the order of the court, he has deposited 8 lakhs and 4 lakhs. No, total amount is 8 lakhs.
8 lakhs, my lord.
He has
On two-
deposited
as per
4
directions,
lakhs in two
two installments, my lord.
He has deposited 8 lakhs as on 30/3/2024. He has deposited 4 lakhs and 4 lakhs on 30/3/2024 and on 66/5/2024. And the outstanding now is 39 lakhs. The same they are ready to pay within 3 months from today. Next parallel, and counsel appearing for the respondent bank submits that there may be a direction to the petitioner to clear off the entire amount within two months. It is submitted that in whatever the incidental expenses or the interest that accrues, they would be informing the petitioner when he has to pay the last installment. And along with that, the petitioner shall pay the amount. Next, having heard the counsel's on this side, is submitted on record. Considering the fact that considering the affidavit that is filed before this court and where he is ready to clear the entire outstanding amount within a period of 3 months, this court is passing the following order. Number 1, he shall pay the 39 lakh rupees in 3 installments each installment at 13 lakhs on first installment by, on or before 7th of December, second installment 7th of January, third installment 7th of February. Number 2, the bank by December 31st shall inform the petitioner what are the other miscellaneous expenses or oblique interest that has to be paid along with the third installment. Number 2, if the petitioner fails to pay any of the installments, immediately the respondent bank is at liberty to initiate the appropriate proceedings. And last, after the entire amount is cleared by the petitioner, the respondent bank shall issue the loan clearance certificate and shall also return the mortgaged, the title documents accordingly disposed of.
Obliged.
Dhananjay Kumar.
Appearing for the petitioner, my lord. We have sent the affidavit, but we have not returned back. My lord.
I will not consider.
My lord, we are ready to pay the outstanding amount. It may be
Nobody
dispersed
is stopping
on my
you.
submission. In my
Why
submission,
were you not present yesterday when the matter is called?
to the
Then why did you made a submission before the court on 28/10/2025 that you will file an affidavit? Not even a day I'll grant.
No, my lord, I am ready to pay the.
If you are ready, who is stopping?
No, my lord, I am ready to pay. Kindly, at sufficient time may be granted, my lord. On my submission.
Where is
to
the
my-
affidavit? You said you will file an affidavit.
Yes, we have not. We did not get the affidavit from the court, Your Honor.
Then that's not the
Kindly have
concern
it
of
on
the-
Monday, my lord. We will present it the same.
On 28/10/2025, it is stated that they will file an undertaking affidavit before this court that they clear the amount. On that condition, the matter, interim order is extended and the matter is directed to be listed on 6/11. When the matter on 6/11/2025, there is no representation on behalf of the petitioner. Today, the matter is posted for dismissal. It is submitted that they have sent the affidavit direct to receive. Finally, list this matter on Monday. If on Monday the affidavit is not filed, this court will not even go into the merits of the matter. On that ground alone, the interim order, the writ petition will be dismissed. List on Monday.
Number 3, Balram ML.
Petition in this case, my lord.
Responded.
Yesterday, due to technical errors, I could not be on the online, my lord.
Yes.
My lord, this matter may be tagged along with another writ petition, 13695 of 2025, my lord.
What is the connection between this and that?
The same loan transactions, my lord. And
Once we pass an order in this, it will follow.
no, my lord, in fact, there is another company is also been tagged in this. This is my brother company. And the total liabilities, in fact, once this property, disposing of this writ petition will not help the bank, my lord. Disposing of this writ petition, which I'm referring, which I'm requesting the court to club the matter, that will settle every issues, my lord. This matter may be.
There are two separate sale notice that has been assailed in these different writ petitions. If my lords may kindly come to their prayer, my lord. The sale notice that they had assailed, that has been already been failed, my lord.
Already been?
Already been failed because it was a prior sale notice that was issued and it was unsuccessful in that regard. And the prayer is.
Let's see the prayer. What is that they're seeking? Issued to quash the sale notice dated 7/10/2024, issued by the respondent bank as per Negligence A. So and so. When was what is the interim order in this?
Interim order is on dated 23/10/2024, my lord. By virtue of which they had to pay deposit 10 lakh rupees, which they have done. But the due payable as on today is more than 5 crores.
No, forget about that. What happened to the sale?
See, it was unsuccessful, my lord, because it was stayed. Subsequently,
They have not conducted.
They have not conducted.
Then the petition becomes infectious.
My respectful submission, my lord. My account has been classified as an NPA during the moratorium period, where Supreme Court has held that the bank should not be classified my accounts as an NPA, my lord.
Where is the prayer you sought in that regard?
The one of my grounds is also like that, my lord.
Grounds, we are not concerned with the grounds.
No,
We are only concerned with the prayer.
No, my prayer
And
is
the-
to,
And the grounds in support of the prayer.
yes, my lord. My prayer at page number 9, my lord,
Yes, I am looking
to
at.
quash the same notice issued on 7/10/2024, my lord.
That's it. That notice, that is,
No,
it is
no,
not being done.
my lord, the basis for the bank to proceed against, initiate action against me is classification of the NPA, my lord. The Supreme Court, by order dated, my lord, in fact, has held that.
No, Mr. Counsel, please understand. There will be a relief that is sought by the petitioner, which will be considered by the court.
Yes, my lord.
Court will not assume
No, no,
anything.
my lord, in fact, my grounds is also for quashing this sale notice. I
Prayer-
understand, my lord.
Prayer is for crashing or grounds are for crashing?
No, my lord, in fact, prayer is to quash the sale notice issued by the bank, my lord.
So that is over.
The prayer, to support my prayer, my lord, the grounds which I have urged is, my lord, is also one of the grounds.
Grounds you can urge before the DRT also.
I may be permitted to do that, my lord. In fact, I may be permitted to agitate before the DRT with the liberty to approach the DRT with a specific period, my lord. And
When is the notice?
The notice was back in 2024. my lord,
24,
the
my,
exact date.
I'll say, subject to the law of limitation, and
No, ma'am.
whatever is.
no, I'm very much within the limitation period before this court, my lord. This whatever.
Section 14.
Yes,
Section
yes,
14 of the
yes,
limitation. Act.
yes, ma'am.
If it is not, if it is from the original date of order, if he is not within limitation, it will go.
My another submission, my lord. Another repetition, my lord. In fact, my entire, I'm not saying.
No, please give the number. I will take it up on Monday. I will dispose it off on that day.
Please, my lord.
Please come.
This is repetition number
Take that number and list it on Monday.
28563 of 2024.
The present petition is filed, questioning the following prayer, seeking the following prayer.
I'll write it.
It is stated that the respondents have declared the account of the petitioner as NPA during August 2021, which period the pandemic was at the peak level. The government had imposed strict guidelines, and in the said period, no one can move outside the house. The restrictions were imposed from March 2020 itself, and Reserve Bank of India had issued guidelines regarding the maintenance of the loan accounts of the banks and financial institutions. The Reserve Bank of India issued circulars about the classification of the assets, and instead of proceeding to recover the loan by classifying the accounts as an NPA, but directed all the banks and financial institutions to fund the borrowers to sustain the effect of the pandemic. But the bank has declared the account as NPA during August 2020. It is stated that the petitioners have paid more than 2.05 crores after the account is being classified as NPA. The bank has issued the separate demand notice to the company as well as the partnership firm, and also the possession notice. But the bank has preferred to issue single notice to enforce the liability. And according to the grounds that are stated, declaring the account as NPA is contrary to law, and the law laid down by the Apex Court, as well as the guidelines issued by the Reserve Bank of India. When it comes to the prayer, the learned counsel appearing for the petitioner has argued in line with the grounds and stated that the declaring the asset as a non-performing asset itself is bad. Learned counsel appearing for the respondent bank submits that the prayer that is sought is questioning to quash the sale notice dated 7/10/2024. It is submitted that this court, a coordinate bench of this court had granted the stay
2310.
23/10/2024, my lord.
on 23/10/2024 on the condition that the petitioner shall pay an amount of rupees 10 lakhs. And as on today, the outstanding is 5
No,
5 crores 32 lakhs more.
5 crore 32 lakhs.
Odd.
It is
5 crores 32 lakhs 2,740.
32 lakhs and odd. It is submitted that as per the order passed by the court, he has paid 10 lakh rupees.
Please.
He has paid 10 lakh rupees. It is submitted that when they have questioned the auction sale notice and the auction itself and the sale itself could not be conducted on the day, nothing survives for consideration in this writ petition. It is submitted that if the petitioner wants to agitate any other rights, he has to go before the DRT, and this court has no jurisdiction. And when he has an effective alternative remedy, the writ petition is not maintainable. Next para. Having heard the counsels on either side, there is a material not required. The prayer that is sought in the writ petition is about questioning the sale notice. He has not sought any specific prayer with regard to the declaring of the illegality in declaring the account NPA. And the writ petition is filed on 23/10/2024. The 24. In view of the interim order, he paid the amount and the sale was also not conducted. Hence, as rightly argued by the land counsel for the respondent bank, nothing remains to be adjudicated before this court. And the other grounds that are raised by the petitioner, he can raise all these grounds by approaching the DRT. Land counsel for the petitioner submits that a reasonable time may be granted to approach the DRT. Next para. There is a limitation to file an application to approach the DRT. Whatever is the time the writ petition is pending before this court, from the date of petition till the date of till whatever time this court grants for approaching the DRT, it would be covered under section 14 of the Limitation Act. But however, with regard to the cause of action and other things, it has to be independently dealt with by the tribunal. Hence, in that view of the matter, this court is passing the following order. The writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy before the DRT. The petitioner, the respondent bank shall not take any coercive steps till 8th of December, 1 month.
2 weeks, my lord.
No,
Kindly request.
You are all happily keeping quiet for this much of time.
My lord, we are facilitating the bank to recover the entire money.
For 4 weeks time, till 7th.
No,
of
December.
Till 8th of December, the bank shall not take any coercive steps. The DRT is at liberty to decide the limitation aspect as far as the pendency of the petition before this court is concerned. That is the section 14 of the Limitation Act. We will come to the benefit of the petitioner. Apart from that, other limitation aspects are kept open.
Till number 4, Kamaya VP, for petitioner H.N. Vasudevan.
Sorry, my lord, yesterday I was
Yes.
not able to present.
Yes.
But the petitioner is the owner of the property. That is the respondent number 1 has seized and thrown away the petitioner from the possession of the property. Our petitioner has been dispossessed from the possession of the property. Whether the outstanding loan claimed by the respondent is 22,42,626. We will pay portion of the amount, my lord. Possession may be reinstated. So all our materials are in the house, my lord. We are not able to.
Lord,
We are,
Sales
we are requesting for
As I submitted
regularization.
yesterday, sales certificate has already been issued in favor of an auction purchaser.
No, they can take the things.
That they can approach the bank, that they can work it out, because there is already.
As far as that relief is concerned, I'll permit them to
Even
take you
without issue.
all your things.
My lord, I will implement the purchaser as a party, my lord, without.
If you plead the purchaser as a party, this court has no power to grant any kind of orders. Already valuable rights have accrued in his favor, and now a situation has come which is irreversible.
Let the furnish information, my lord, we will approach the DRT challenging this. Let the furnish information.
That has been already provided to the borrower.
No, we have logged where they will provide. We are outside the street. We are in street.
And further also, I'll ask him to provide
It
everything.
was only day before yesterday.
Give him all the material, and whatever he wants to take from the premises, let him take.
No, even there is no address of the purchaser, my lord. It's only.
They will give all that.
That's the furnishment.
You please go to the bank.
Name is Mele.
So if we go, my lord, they will not furnish.
I will direct it through by way of this order. The present writ petition is filed.
I may be permitted to place the sales certificate on record, copy of this.
Take that. The writ petition is filed, questioning the petition is filed seeking the following relief, extract the relief. It is stated that it is a case of the petitioner that an order is passed for the magistrate in criminal miscellaneous number 256 of 2021 on 5/4/2025 under section 14 of the Surface Act. No notice was served to the petitioner in criminal miscellaneous number 74 of 2025. It is stated that the proceedings under the Surface Act are not applicable since it is a residential property and no notice is issued before initiating the proceedings. It is stated that the respondents have acted arbitrarily by seizing the movable valuables and cash from the house, which is not permissible under section 14 of the Act. Law permits only the secured immovable property to be taken by complying the principles of natural justice. It is submitted that they are ready to deposit the amount if a reasonable time is granted, and the bank cannot be permitted to forcibly take possession. When counsel appearing for the respondent bank has placed on record the sale certificate that is issued pursuant to the sale dated, auction dated.
One more submission. They have not furnished the detail of auction after issuing of
Auction,
notice.
what is auction date?
Yes, it does not have any details.
It is submitted that they have issued a sale certificate.
Even it is issued, my lord, after filing of this writ petition, notice is ordered to the respondent.
Sale certificate is issued. It is submitted that once the sale certificate is, once the auction notice is issued, question of redeeming the mortgage does not arise. Further, the petitioner cannot maintain the writ petition before this court as far as taking the movables in the house are concerned. He can approach the bank. In response to that, land counsel for the respondent petitioner submits that the details pertaining to the auction purchaser and all the relevant details are not furnished. If all these details are furnished, he would be approaching the DRT, questioning the illegality in conducting the sale. Next para. Having heard the so and so. The petitioner has questioned the section notice issue, the order that's passed under section 14. If the petitioner is agreed by an order under section 14 or any of the proceedings and the notice that is issued by the bank, its remedy is to go before the DRT under section 17. Further, the request of the petitioner that he is ready to deposit the amount cannot be considered as the auction notice is issued And in fact, now the sale certificate is also issued. Then coming to the submission that the articles or the movables are lying in the house, the petitioner shall approach the bank and the bank shall consider and permit the petitioner to take away the belongings. The petitioner, to avail the alternative remedy, he requires all the relevant details pertaining to the sale and the auction purchases. When the petitioner approaches the bank shall give all the necessary details to the petitioner. Accordingly, the writ petition is disposed of.
Till number 5, matters. Pocket listening.
My lords, I appear for the petitioner.
You have not
received the petition copy in this. If petition copy is served, I'll seek the instructions and I'll just go through the petition.
Yes.
My lords, there is an office objection that came subsequently for furnishing the petition of the CMS petition. I may be dispensed from furnishing the same. The primary ground that is there in this case is that this
has not been made a party in this writ petition. The respondent company had taken over the loan portion from DHFL and also. What is this complainant?
The petitioner, my lords, per se, this was a joint loan taken by the husband and the wife, and she was not a party in the Section 14 order that came through. So she had no knowledge about the loan transaction per se that took place. My lords, if I may be permitted a week's time.
Make a party. The other co-borrower also.
Yes, he was a my lords, if a week's time is permitted, I will come back to you with the correct
The
facts of
office
the case.
objection shall be complied with and the copy of the writ petition shall be served on the counsel appearing for the respondent bank. What's
Certainly.
your name?
Sridevi, my lord.
Say some Patel.
Dai Patil is my husband. He's my husband.
Yes, they shall be served on the council. This is matter after a week. Yes, 6.
Till number 6.
Obliged, my lords.
So Kumar,
What are the office objections?
1 week time.
A week's time.
till number 7.
For the bank, my lord. Copy has not served.
No, in 1 minute, any stay is there in this?
No, ma'am.
Oh, yes. A week's time, serve the copy. The council says the copy of the writ petition on the council for the respondent. 7.
7 minute is 6.
Appear for the petitioner, your lordship. Direct the any standing counsel for the
This is the
SBI.
bank.
SBI, State Bank of India.
Yes, Mr. Vignesh Shetty. Mr. Vignesh Shetty is directed to take notice. Petitioner shall serve the copy of the writ petition and the office objection shall be complied with.
Now, today only, I will
Shall be
comply.
complied with within a week or else the writ petition will be dismissed on that ground.
Permit me to comply.
This is matter on 18th of November. By that time, the learned counsel, the respondent shall get specific instructions.
Hearing on the idea, till number 8.
My lord, in this case, appear for
Eight
petitioner.
actually.
My lord, in this matter, I got the one citation of the apex court, my lord. That is 150 pages, my lord. It is not downloading in the library.
I'm
my
sorry,
lord.
I will not adjourn the matter. You please tell, I will ask them to get the book. What is the citation?
Please, my lord.
Yes,
Yes.
get that citation.
Please,
Next, for the
ma'am.
next matter, give to the court officer.
My lord, it is not downloading, my lord. But since the morning, I am trying, my lord, in the library. There is a citation I will give. Please, my lord. Please, my lord.
Till number 9. P. Rajeshri. P. Raju.
My lord, for the petitioner, my lord.
For the
Yes.
impleading applicant in this matter, my lords. I'm
My-
the subsequent auction purchaser in this matter.
Oh, you already purchased the property.
Please, my lords.
My lord,
Amount of 56 lakhs has also been paid and a sale certificate confirmation letter was issued in my favor on 28/20/25. Subsequently, my lord, a registered sale certificate and possession has not been
So
handed
what
over.
is this order with liberty in this regard and calling upon the respondent not to induct anybody into subject property until the next date of hearing? Release this petition on 12/9.
Possession has not been handed over to me, my lord. I'm not in possession.
No. What is that? It is questioned in this writ petition.
My lord, sale, my lord, sale before this honorable court. My lord, sale notice at my lord, page number 45.
Question number?
page number 45 of my statement of objections.
My lord,
no,
statement of objection documents are not served, be it as it may be.
No,
With
I'm
regard,
looking at your prayer. What is
my,
your
my prayer is to set aside the auction notice, my lord, and
On
all
what
the actions.
ground?
My lord, now if you're on my kindly peruse, page number 73 was the auction notice. Page number 76, I had given the representation seeking for an OTS amount at 46 lakhs. The sale minimum value was fixed at 54 lakhs. I had given an OTS opportunity at 47 lakhs, my lord. Then it came to my knowledge that the bank in its website has also published based on the RBI regulation at Annexure T, my lord, page number 77. As per that, as on July, my outstanding was 33 lakhs and regarding one loan account, and there was no outstanding in respect of the second loan account. This is what is published in their website. Despite that, I had sought for OTS at 47 lakhs, my lord. It was denied, and they went ahead conducting the auction, my lord. And it was they say that it is been fixed at 56 lakhs, my lord. I am in the second round of this, litigation before this honorable court. There was a delay in depositing the money. I'm not on that, my lord. But substantial amount has been paid. Over 30 lakhs has been deposited in view of this honorable court's order, and the outstanding is much lesser. That is the reason I am seeking to set aside the auction proceedings, my lord.
My lord, my instruction, my lord, pursuant to this writ petition, my lord, they are not paid any money. My lord, I am a proxy counsel in this matter. Apart from that,
That's a
sale notice, my lord, assailed before this honorable court. Sale confirmation taken place, sale certificate issued on the very same day, my lord, interim order has been granted by this honorable court. And my lord, nothing survived. At the most, my lord, they have, my lord, two rounds of, my lord, earlier rounds of application, they went to DRT. They are not complied the interim order. Matter got dismissed. They filed a writ petition before this honorable court. Writ petition, they withdrew it. No, my lord, in this junction, my lord, after issuance of sale certificate, my lord, my lord, this relief sought before this honorable court is not.
Go to the DRT.
My lord.
Go to the DRT and
My
question
lord, my kindly peruse page number 77. That's all is my request, my lord. As per their statement, my outstanding is 33 lakhs. When I'm ready to pay 47 lakhs, they could have taken it as well as closed the matter on the previous day, even before the matter went up to auction. That is my humble submission, my lord. The prima facie case is made out, my lord, that there is grave violation, my lord.
Made out a prima facie case. They have conducted the auction. And the auction has to be set aside.
Yes,
all these issues, DRT will decide whether it is your their sale notification is bad, good, what is your outstanding, what are all happening. Like, go to the DRT. DRT is a place all this you will get you will get an opportunity to agitate so many disputed questions, which this court cannot decide.
My lord, my humble submission is yes, alternative remedy was available. Why it is not approached is only because of this, my lord. Though there is substantial difference in the value, that is the reason I am before this honorable court, my lord.
No, he is also there now. Option purchaser has also come into picture. Now, under in the settled law, unless and until the sales certificate or the auction proceedings are set aside by the DRT, saying that there is a fraud played by the bank, you are not entitled for any relief, because already auction conducted, sales certificate is issued. So please go to the DRT. I will give you a breathing time of 4 weeks.
I seek the honorable court's intervention to secure my interest till the time I approach the
4
DRT.
weeks.
Much obliged.
With the Lord's permission, one submission, my lords, because the auction sale notice was issued on 9/7. They give the proposal on 18/8. There again a delay wherein I've already paid 56 lakhs. My money is also pending, and I've not even been given the possession. I'm also at loss.
So, you know, I'm this, whatever is the interim order, 4 weeks.
Please, madam.
Let them go. You also approach the DRT. They have to make you as a party now.
Please, madam. Grateful,
Please
madam.
come. The writ petition is filed, seeking the following prayer. It is stated that the petitioner is absolute owner of the scheduled property at item number 2, 1 and 2, acquired under partition deed amongst the family members, and she has mortgaged the property to the bank and secured a loan of 32 lakhs. The petitioners have further obtained mortgage loan facility of 22 lakhs along their daughter and son by sanction letter dated 17/6/2019. In furtherance of the earlier mortgage deed, the first petitioner further executed supplementary letter of evidence of deposit of title deeds of property dated 26/2019. Totally, they have taken 54 lakhs. A demand notice under section 13(2) of the Surface Act was issued on 3/6/2021 and 15/7/2021. Later, the possession notice was issued on 12/10/2022, and the same was challenged before the DRT in SA number 739 of 2022 and SA number 738 of 2022, along with which IA number 2925 of 2022 and 2926 of 2022 verified seeking stay of the possession notice dated 12/10/2022. And a conditional stay was granted on 4/11/2022. In SA 739 of 2022, the petitioner was directed to pay deposit 8,30,000, being 25% in 2 installments within 1 month. First installment of 4,15,000 to be paid on or before 19/11/2022, and second installment of 4,15,000 to be paid on or before 4/12/2022. And in SA number 738 of 2022, order to deposit 6,70,000 in 2 installments within 1 month. First installment of 3,35,000 to be paid on or before 19/11/2022, and second installment of 3,35,000 on or before 4/12/2022. Later, as I could not pay the amount as time-bound manner, the stay was vacated. Then a notice was issued to vacate the premises on 21/12/2023. And in lieu of the order passed under section 14 of the Surface Act in criminal miscellaneous number 50139 and 50140 of 2023. And the petitioner was called upon to pay 39,79,031.75 and 31,55,636.69 as on 29/11/2023. Then they filed WP number 966 of 2024, and a conditional stay was granted on 10/1/2024, subject to deposit of 15 lakhs in 9 weeks. Interim order was extended on 1/2/2024, 22/2024, 28/2/2024, 28/3/2024, and 16/4/2024. And in respect to the other account, WP number 964 of 2024 was filed. And on the same day, order was also granted in that. The bank has taken the physical possession on 8/5/2025. The 2 petitions are dismissed. As withdrawn.
Disposed as withdrawn.
Both the petitions were dismissed as withdrawn. Then the respondents have issued the e-auction notice on 9/7/2025. And the auction was scheduled to be held on 19/8/2025. The petitioners have found a purchaser for the scheduled property and approached the bank on 18/8/2025, offering for an OTA settlement of 47 lakhs and the payment to be cleared within 15 days. The respondent bank orally informed that it would consider the same subject to confirmation of the head office. However, on 19/8/2025 afternoon, the petitioners are orally informed that the auction was proceeded with the sale was confirmed in favor of the prospective bidder. Though he has sought for the details, the same were not furnished. Next para, learn counsel, and which made them to come before the court. Next para, learn counsel appearing for the petitioner submits that when the petitioner was ready to pay the amount and they were ready for the one-time settlement, the respondent bank, without giving an opportunity to the petitioner, has put the property to auction. The outstanding according to the petitioner is 32 lakhs.
My lord, as per their statement published on their website, it is 33,67,000.
It is 33 lakhs, 67 lakhs. And the offset price is?
My lord, in my sale notice, I mentioned outstanding is, my lord, 55.76 lakh.
No, according to her, that
According.
is it. So it is submitted.
Auction price is, my lord, 54 lakh 99,000.
54 lakh 99,000. It is submitted that the bank, there is no transparency in the manner in which the bank has conducted the sale. Hence, the sale has to be set aside. Set aside. It is further submitted that by order dated 3/9/2025, the coordinate bench of this court has passed an order not to induct third party until the next date of hearing. It is submitted that the writ petition may be allowed. Next para. When counsel appearing for the respondent bank submits that the property, according as per the sale notice, the outstanding amount is
55, my lord, 0.76. My lord, 55 lakh 76,000.
55 lakhs 76,000.
As on 1/7/2025.
And the offset price is
54 point, my lord, 999.
54.99 was the price.
And we conducted the auction for, my lord, 56 lakh.
And the auction was conducted for 56 lakhs. It is submitted that the sale certificate was issued.
Issued on, my lord, 3/9/2025.
The sale certificate is he's already come on record, or he has yet to come?
I've filed my impleading application along with
Formally
not all as
allowed?
follows.
Not
Not yet
allowed.
allowed, my lords.
Formally it can be allowed.
Then what did you write? So now even the auction purchaser has filed the implead petition to implead himself in these proceedings. It is submitted that when the notice is certain that there is no illegality in conducting the auction, and bank has issued the sale notification and conducted the auction as per the Surface Act and as per the guidelines issued by the Reserve Bank of India. It is submitted that the writ petition is not maintainable and the petitioner is not entitled for any relief from this court. Next docket order, IA number so and so is filed, stating that the implead party is a auction purchaser, auction purchaser, and is a proper and necessary party to the proceedings. In view of the interim orders that is granted by the court, the position is not delivered to the petitioner, to the implead petitioner by the bank. In these circumstances, the auction purchaser is a proper and necessary party. Accordingly, he is impleaded. This should be a docket order. The next para, the auction purchaser who is impleaded by this court submits that because of the impugned order, though he has paid the entire amount.
Please, we have
that he has paid the entire amount.
And we have issued a sale certificate also.
Entire amount and sale certificate is issued, and he is not in a position to enjoy the property in view of the orders passed by this court, and there are no, the petitioner is not entitled for any relief from this court. Next para. In this case, the sale notice was questioned by the time, and the bank went ahead, conducted the auction, and received the entire amount from the auction purchaser, and the sale certificate is issued. The petitioner is raising several grounds, pointing out that there is some irregularity in conducting the auction, and the auction has to be set aside, and the bank shall act, and the bank shall be directed to accept her proposal. Any of the reliefs that are sought by the petitioner, this court cannot grant for the reason, once the auction notice is issued, the petitioner's plea for a payment and redemption of mortgage, this court cannot consider unless and until the sale is held to be bad and it is set aside. Whether the sale is validly conducted or not by the bank, all those issues and the disputed questions of fact, this court cannot go into. And the effective alternative remedy for deciding all these questions is before the DRT. Hence, this court is not inclined to entertain this writ petition. Accordingly, this court is passing the following order. The writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy in accordance with law and the law of limitation. Number 2, from 7th of November till December 8th, the order that is passed by a coordinate bench of this court that the bank shall not induct anybody into the subject property shall continue accordingly disposed of.
My lord, one submission, my lord. Sale certificate was issued, it was not registered. That stay may be. Sale certificate was only issued. Document was not in.
Say so that it is registered. I said only sale certificate.
Yeah. No,
Yes.
much of it. Huh?
Yes.
Sale number 10 and 11 adjourned. Sale number 12, Suma K.
Petitioner. In this case, there was an e-auction which happened on 31/2025.
I have a question before this court.
I have questioned to quash the sale certificate and the e-auction because the right, title and possession is not with the bank. The bank itself does not have the property. They have not verified the details and they have e-auctioned the property. So the right, title and question of the property of 10 cents along with the house is not with the bank. What do? They have a survey of the property.
Who are you? You are the borrower.
Auction purchaser. I am the auction purchaser. What happens is the bank has e-auctioned the property on 31/2025. Next day itself, they sanction a loan of 40 lakhs. On the day of auction, I pay 26 lakhs. Later, the remaining amount, February and March, I pay through EMIs. Later, when I go, the bank makes a survey of the property. That time they come to know that there is no property only of 10 cents. So it's a big fraud.
Lord, this is the auction purchase writ petition. And my lord, this is the residential property. And the bank, which has been mortgaged to the bank, and the bank has sold it and issued sale certificate. Lord, in respect of a certain portion, there is a deviation, but it's a residential house. It has been sold as is, where is basis, and they should have verified. I'll file my objections, let them file. My lord, this has to be heard. I have to place all the documents on record.
Thing is, in all these cases, bank should have some responsibility. He shouldn't say that, first of all, when you're when you're sanctioning the loan, when people are mortgaging the properties, at that time there should be, you should verify the property.
Yes,
and when
Lord,
you're
that was
selling
done.
it,
Yes,
when you're
Lord.
selling it, like any other seller, you have your responsibility.
Yes, my lord, that was done. In fact, everything is clear. It is vacant property. It was a house which was mortgaged, and house in sale certificate was issued. They are not ready to take
No,
sale
in this
certificate.
as and where condition, we have no responsibility.
No, my lord.
Only our responsibility is to take money and create problem between two people.
No, my lord. In this case, there is a deviation of the
File your
building.
objection.
I'll file objections. Let them serve a copy on my. I undertake to appear, my lord.
So
Let them serve a copy of the report.
The objection shall be filed by
2 weeks
10th
time,
of
maybe.
December.
Yes, madam. I'll file.
So and so takes
Yes,
notice.
yes, yes, madam.
Number 13.
Appear for respondent in this matter, my lord.
Appearing for the petitioner in this matter, my lord, I am challenged the criminal miscellaneous case filed by the criminal miscellaneous case, my lord, I filed by the respondent. After filing of the annexure A, my lord, I have made the payment of rupees 29,79,000, my lord. The remaining is 81,204.
81,000.
81,204 according to my calculation.
Is it outstanding?
Remaining,
After
Remaining.
in the petition,
may I submit, my lord?
Yes.
As on 30/10/2025, my lord, it is 5,21,000 his outstanding due in this account, my lord.
When
If they
will you
make the
pay?
payment, this account will be closed, my lord.
When will you pay?
My lord, we have totally paid the 29 lakhs 79,000.
They say outstanding is 5,21,000, not
According to
88.
our calculation, 18,1,000.
No, your calculation is not what they say is the calculation. You have to go and verify with the bank. And
Yes.
please, I'll adjourn this matter by a week. By the time you go to the bank and get what is outstanding, and when you are ready to pay,
Yes,
file an
ma'am.
affidavit before the court, will dispose of the writ petition. Learn
Even
counsel for the
stay may be
petitioners.
given.
Huh?
Stay on the criminal.
Learn counsel for the
We are not
petitioner
taking
submits.
any.
Learn counsel for the petitioner submits that the outstanding is 81,000. And the learn counsel appearing for the respondent bank submits that as on today, the outstanding
That's
is 5
done.
lakh.
30/10, my lord.
39.
As on 30/10, the outstanding is 5,21,000. Then counsel for the petitioner submits that. They will approach the bank, and whatever is the outstanding, they're ready to set it the same. List this matter on November 25th. By that time, the petitioner shall file an affidavit before this court when he is going to, when the petitioner is going to pay the outstanding amount.
Stay may be granted till then.
Till such time, the respondent shall not take any coercive steps.
Sale number 14.
Appearing for the respondent bank, my lord, in this case, they had filed an SC on a similar cause of action.
Land council, a memo is filed seeking to withdraw the petition, accordingly dismissed as withdrawn. The Passover matter.
Passover, sale number 8. Dismiss sale number 8.
Appearing for the respondent bank.
Yes. Yeah, what did the Supreme Court say?
My lord,
First of all, what is this writ petition?
writ
Then we will
petition,
go
my
into
lord,
the
I am
law.
seeking direction to the direction regularize my account. It has declared as NPA, non-payment of amount or loan amount during the period of COVID period and thereafter. There is a RBI guidelines, my lord, in this as per.
Come to the prayer, what did
Ah,
you
yes,
say?
I
my
make
lord.
one submission, my lord. My lord, what they have challenged is a possession notice. In fact, my lord, they have voluntarily
No,
submitted.
that's what she's saying now.
Please, please.
Yes.
I know that last time what I have seen.
Last time also.
What is that prayer? Issue
Prayer, my
direct-
lord, page number
issue
9, my lord.
To the so-and-so.
Respondent to regularize the account of the petitioner and consequently restrain the respondent from taking out portion as per annexure D of the scheduled property.
Why would we direct them to do it? Why would the High Court tell the bank to regularize your account? That is between you and the bank. What you are supposed, as per the RBI guidelines,
Yes.
whatever they are supposed to do, they'll do. You show one provision which they have violated, and why shall there be a mandamus to them?
My lord, as per this Supreme Court citations, my lord,
We can't read the Supreme Court judgment like that. Supreme Court never say High Court direct them to do everything. We cannot tell all that. To regularize the account, whatever the RBI rules are, as per that they
my
will.
lord, as per this judgment, my lord, NPA account not directed the banks to make the NPA of the account holders and that is the directions, my lord. As per this citations.
Please come to your affidavit, your petition. Let us see, what did you say?
Yes, ma'am.
What did you say? They've already
My lord,
issued.
para number 13.
When was the 13th notice issued to you?
13, my lord, it is not challenging any notice here in my lord. Only I am seeking
Without
direction.
challenging anything, you can't come to this court with this.
My lord, already there is an order for taking position, my lord, in favor of the bank. They have filed criminal miss 7731/2023 that has been already disposed of. My lord, this is a small scale industries, my lord. The property is more than.
Your account is declared as a non-performing
Yes, my
asset
lord.
on 36/20/23. As
23.
on that day, there is no pandemic.
Hello.
On that day, they
Due
need
to
to
the
serve.
non-payment of loan amount, my lord, that was made by the bank, my lord. During the period of COVID period, they have not.
What is COVID period 36/20/23? Some
In view of
gentlemen,
non-payment of loan amount during the period of COVID period, my lord, they have considered that in the year 2023, my lord.
when will they, for consecutively for 90 days, if you don't pay, then they will declare it as NPA. 36/20/23.
Already he has
They-
paid more than 50 lakh, my lord.
The present writ petition.
My
is
lord,
filed.
my citation may be
So I will
quoted, my
record
lord.
that.
Please.
The present writ petition is filed seeking the following prayer. The petitioner has obtained a loan of rupees 1 crore from the bank by mortgaging the property. It is stated that as the petitioner has committed default in payment of monthly installment, the secured creditor had declared the petitioner's loan account as non-performing asset on 36/20/23 and issued statutory notice It is stated that despite receiving the statutory notice, they failed to discharge the liability in full within the statutory period. And they've also, it is stated that they have filed criminal miscellaneous 7731 of 2023 and an order was passed under section 14 of the Surface Act.
My lordship, one submission. In the meantime, my lord, this honorable court has granted an interim order. In the interim, as per the interim order, my lord, I have deposited the 50,000, my lord, thereafter.
It is stated that after the 13/4, when when the bank has approached the ACMM, 31st ACMM, the petitioner approached the bank to clear the debt. The bank was not ready to issue the OTS, and the petitioner asked for the balance. The respondent have issued a statement for rupees 1 crore 44 lakhs 5,460. When they have approached the High Court, when did they approach by filing what writ petition?
My lord, this order passed in the petition on 27 May 2024,
It is a
annexure B1,
It is stated
page
that
number 28, my lord.
approached, page number?
28 is the order, my lord.
That is Justice Krishna Kumar's order.
Yes, my lord.
The petitioner has approached this court by filing WP number
OAS pending before the
10483 of
DRT, my lord.
dated 27th May 2024. Questioning the order that's passed in criminal miscellaneous number 7731 of 2023. This court, the coordinate bench of this court has directed the DRT to consider and pass appropriate orders in essay number 472 of 2023, which is posted to 24/6/2024 in accordance with law.
That is pending, my lord. SA 472 of 23 is pending. OA 1042 of 23 is also pending.
Subject to compliance with the directions issued by the court in interim order dated 5/4/2024, passed in the writ petition, shall continue and remain in force and subsist between the party till disposal of essay number 472 of 2023. The petitioner, it is stated that they have deposited 50 lakhs. They have paid an amount of rupees 50 lakhs to the respondent bank as per the order They've approached the bank and requested them to regularize the account. As it is a business account, there are work orders issued by the company. Then a notice was issued to vacate the premises on 1/2/2025. And the petitioners have approached the bank to clear the debt and request the bank to regularize the account. And the respondent bank has rejected the request and has taken position. On that, with the said relief, the petitioner is before this court. In this writ petition, there is no interim order. Then counsel for the petitioner submits that as the petitioner has paid the amount during the COVID period, the bank has issued declared the asset as a non-performing asset. She relies on a judgment of the Honorable Apex Court in case of Small Scale Industries Manufacturers Association versus Union of India and others, 2021 8 HCC 511. Relying on this, it is submitted that when during the COVID period, when certain guidelines are issued by the bank, issued by the RBI, at that time the banks cannot declare the asset as a non-performing asset. In the light of the said judgment, all the proceedings and issuance of NPA is bad, and also the court has to there shall be a direction to the bank to regularize the account. Next part. Learned counsel appearing for the respondents of SAT. Already the essay is pending before the court.
Essay and OA is also pending.
Then essay and OA are pending before the tribunal. And whatever the relief that the petitioner is entitled, all those grounds can be raised before the tribunal, and they cannot come before this court seeking such a relief. Further, it is submitted that the account is, even according to the petitioner itself, the account is declared as a non-performing asset on 30/6/2023, and this judgment which she is relying upon is on 2020. It's reported in 2021 8 SCC 511. It is submitted that the question of COVID period and declaring it during the COVID period, RBI guidelines will not apply to the facts of the case, and it is submitted that the petition needs to be dismissed. Next paragraph. Having heard so and so, the petitioner has come before this court seeking a prayer that the account has to be regularized, and regularize the account of the petitioner, and consequently restrain the respondent from taking over the possession. Earlier, when a possession notice was issued, when an order was passed by the magistrate under section 14, the same were questioned before the DRT. And during were pending DRT for proceedings, they have approached this court by filing a writ petition, and the court has directed the DRT to dispose of the matter, and also dispose of the matter. When the DRT and before the DRT, when an OA and SA are pending, why the petitioner has come up before this court seeking this relief? There is no convincing reason for that. This court cannot direct the bank to regularize the account, contrary to the guidelines issued by the RBI, and there cannot be a mandamus to the bank asking them to do a particular act when the petitioner in the entire writ petition has not even stated what the bank is legally obligated to do and what the bank has not done. The petitioner is approaching the court by filing one petition after the other, when without proceeding, without taking these asking for these reliefs in the pending way. In that view of the matter, this court do not find any reasons to interfere, and accordingly the writ petition is dismissed.